Good morning, everybody. How are you doing today? We're back for day two of the final week of the Depp v. Heard trial. First and foremost, I want to thank all of those of you who were with me yesterday. I really, really appreciate it. Those who joined me, it was fun having you on board. I really enjoyed having you with me yesterday. So thanks to those. And several of you stuck around for hours. I love the comments. I love the interaction. I appreciate it. I kind of plugged into a channel called Legal Bites, which we'll be doing again today. And one of the reasons why I did that is because I got really kind of into this trial. My background, I'm a nerd. I'm an analyst by trade. That's what I do. And so this trial has been very interesting to me from a cultural standpoint. It's not a left or right issue. It's simply more of a right or wrong issue, as I've said before. And as I've looked at this more and more, I can see that somebody lied. Because Amber Heard's story about abuse, when you look at the evidence, when you look at all the facts, just does not seem to pan out. And so you'll see that as you go through this trial with me. I hope you'll stay with me today. I look forward to having you on board. I wanted to go over a few things for those of you who maybe weren't here yesterday and here today for the first time. I want to go over a few quickly, if I might. So, first of all, yesterday's trial. For some of you who are less nerdy or not as into it, you might have gotten a little boring for you at points, especially when it came to the cross-examination by a gentleman named Dennison on the Depp team, Johnny Depp's team. But yesterday was fantastic for them from this standpoint. All three witnesses who came up yesterday were all witnesses for Amber Heard's team. And the first one was Dr. Moore, who's a hand specialist, orthopedic surgeon. Spent 15 minutes on all his credentials. And after they were done talking about all his credentials and how he testified that Johnny's injury when he lost his hand, and then unfortunately they showed really graphic image of what his finger, not his hand, lost his finger, the tip of his finger. They showed a really graphic image of what the tip of his finger looked like. It was bad, but and it was like bam. It was like there was no like warning that the picture was coming, but it was even worse than I thought it was. But this doctor basically testified that he couldn't have lost his finger the way he said, which was basically that Amber threw a whiskey bottle at him, full whiskey bottle at him, while his hand was on the counter of the bar in the house, and the bottle connected with the bar, cut the tip of his finger off. Camille, who's been fantastic on Johnny's team, when she got to the cross-examination, just ate that guy's lunch because it came down to the point where he could not rule out that he lost the tip of his finger from a bottle injury. Camille even showed me the picture of the broken whiskey bottle on the floor, blood all around the blood drops on the floor of the bar. It was hilarious. So she just took him out. Then the next witness that came up was Dr. Spiegel, or I call Dr. Schmiegel. I promise you, this guy looks like he looks like Doc from Back to the Future, Christopher Lloyd. I lost everybody for a second there. My apologies. I have no idea what just happened. But at least the camera's back up and running again. I apologize for that. Anyway, back to Dr. Smeagol, as I call him. His name's Dr. Spiegel. Psychiatrist, so full of himself. And they got Dennison. Dennison's really kind of an unassuming, on Depp's side, Dennison, the attorney, he's kind of unassuming, kind of a Matlock / Columbo type character. For those of you who are under 40, you won't get those references. Don't worry about it. Go look it up. But he's very kind of mild-mannered, and he seems like he doesn't really know what he's talking about and fumble around, but then he hits you. He just got some zingers that hit you. And he just ate Smeagol's lunch yesterday. You got to go back and watch. There's some hilarious memes of this guy all over social media. Dr. Spiegel / Christopher Lloyd / Smeagol, you name it. The memes are hilarious. You got to go check them out. That part of the trial was hilarious. And then the third witness, the Amber Heard team brought up yesterday was I call her Hollywood Karen. She was basically a producer. I believe her first name actually is Karen or Kareen. And she said she was a producer in Hollywood. And she produced all these movies and award-winning and all this kind of stuff. And Dennison ate her lunch. She didn't know Chris Pine was in Star Trek. She wasn't familiar with any of his other movies because she was trying to basically compare Amber Heard's career, what the trajectory would have been, to Jason Momoa's or Chris Pine or Gal Gadot. It was to say she could have made $45 million. It's ridiculous. It was ridiculous. It did us ate her up too. But the best part about yesterday was Amber Heard's team spent 4 hours in those testimonies. They only have 8 hours left. They have now because of that, they only had 8 hours. Now they only have 4 hours left for today, tomorrow, and Thursday. That's it. They got 4 hours of testimony. And Johnny Depp's team has nearly 16 hours, which means the Depp team can literally bring witnesses on for rebuttal. Rebuttals will start taking place today. They can bring witnesses on for rebuttal. Once the Heard teams runs out of time, they can't cross-examine it. So they could just bring witnesses on and do direct with no cross-examination and run out the clock. It is crazy how much the Amber Heard team has wasted their time. It has been ridiculous. They're supposed to be calling Johnny Depp back up to the stand. They may not call him back up to the stand because they only got 4 hours. And Depp has a habit of talking very slowly, and they know that they don't have a whole lot of time. So yesterday we're going to call him up to the stand. Amber Heard's team, I don't know why they want to. He was great on the stand the first time they cross-examined him. It turns out they're saying now they might not. We'll see what happens. But right now, I'm going to get us over, it's got 5 minutes before court starts. I'm going to get us over to the Legal Bites team and see what's going on with those guys. So stand by, and I'll get us over there really quickly. Welcome, everybody. If you have comments, please let me know. Good morning, Lori. Good morning. Hey, David. Good to see you, brother. What's going on? We're going to plug right into the Legal Bites team right now. Part of the reason why I plug into the lawyers, because you'll hear their commentary, because I'm going to be kind of in and out. I have some things that need to take care of in the background, so you're not going to see my face. Although you see my face in the picture, you won't see me live the whole time, but I will answer comments as I can. So let's go ahead and get plugged into those guys. Give me a moment, and we'll share a screen here. See what's going on with the Legal Bites team. There we go. Oh, come on, Steve. My apologies, we lost them. There we go. And we'll get this. Where's the sound? Oh, there we go, guys.
I need to. So there was another question that was related to that other one before. And actually we've got to capture this one here. DLZ Arrow Entropy, thank you very much for this generous super chat. Very generous of you. Appreciate all the time you all sacrifice for this question. Thoughts on why Amber Heard's witnesses are low caliber? Funds issue, lack of prep. I think it's a facts issue. That's my impression.
Well, I have to agree, and I don't want to impugn anybody's character, and I'm not going to do that because we don't know any of these people, but we just see how they do present on the stand, and it does raise a question about the types of personalities that Amber Heard has found attractive in her witnesses. She seems to have selected people who will be combative with an opinion that is
yesterday was a mess.
I think a little bit hard to sell because they don't have the facts in support of it, like you're saying. All they really have to bring is attitude. And I'm just not sure that that is really working for them the way that they maybe hoped it was going to.
Yeah. And here's a question too, but yeah, no, I do agree. Lindsay Schwolgen wants to know, can they object if they run out of time? Yes. Objections are not counted as part of that. No, but I definitely agree. We've got, now looking at it, we've got 2 minutes left until, but we've got everything set up. So I'm keeping track of the courtroom. We'll see how quickly we get things up with the court cameras.
Do we think they rest, or do we think they have another witness?
I think they have at least one more witness.
They gotta arrest as soon as
By the way,
possible.
everyone you guys are watching in the
Or
screen
not,
right now
yeah.
is an attorney.
Agreed.
five.
Agreed.
I'm a
Agreed.
clock. I go tick, tick, tick. Tick, tick goes the clock.
The guy in the lower left, Kurt, is hilarious.
Yes, exactly.
Good morning, by the way.
Good morning.
Michael Gaunt, thank you very much for your generous super chat. Your Brisbane comment means I have to test you on some English places. Loughborough, Bicester, or Worcestershire.
For those watching the comments,
okay, I think
let me
that
know.
one I
Do
know.
you think that
Isn't that
the Hurricanes,
Michael?
they only have 4
Isn't it
hours?
Worcester?
You think they're going to run out of time today?
Worcestershire.
Worcester. Oh my God, I'm
Yeah,
sorry, guys.
Worcestershire.
I know.
Clearly, I need to spend more time in the UK. And Teignmouth, or just
I would say Teignmouth. I think it's probably Teignmouth.
Teignmouth, yeah, not mouth, myth.
Just wait till people start slinging Irish names at you.
Oh dear.
Yeah, he says he didn't give Welsh.
Irish,
He
right?
didn't ask for Welsh pronunciations.
Yes, no Welsh pronunciations.
Welsh is
Loughborough,
A1.
Loughborough,
The chat is
Worcester,
suffering.
Worcester, Loughborough. Okay.
Worcester, really?
I'm getting these in the chat. I know. All the folks from the UK are like just
By the way, for those who are wondering, Steve, why are you streaming these guys' channel like Legal Bites? Because this is her channel, rather than just when Legal Bites. First of all, it's because you know me, and secondly, she's got over 250,000 subscribers already on her YouTube channel. I could use a few more subscribers, and I'm sure you like to hear my commentary as well as just theirs. They're great legal insights, fantastic, but I like to watch to see how well my thoughts are jive with what they're saying. So stay with me. I appreciate you. Thanks.
Bister.
Yes. Oh my gosh. Okay, so funny. Anyhow, well, let's get some questions in before we get silenced by the chat because of court proceedings. Allie Hargrove says, "Can you explain why audio is inadmissible if it has anyone's voice other than AH or JD? The finger incident audio is damning. We've got this in our asked and answered videos. So this is one of the things here is that we've got Johnny here. He just walked in.
Where's Johnny?
Fairfax courtroom.
And now it's, of course, it's gone. Yeah.
Good morning.
Judge is in.
All right. My understanding
So, Allie Hargrove,
I'm
check
not
the
gonna
asked and
jury
answered
out
videos.
to take them back in.
They're
So
all
when
time
they-
stamped,
after we
so you
finish
can
our
find that
motions,
exact
when
question.
they come out, I'll let
Oh,
you
she's
see.
got
resting. They're
motions.
going to do the
Okay, let's
motions.
We've got
just go
motions.
Wow.
Oh, all right.
So based on them resting, you have a motion,
They rested.
and I did receive your
Yay.
memo ahead of
Oh.
time.
I got
Okay,
one
we'll
right
do that.
after 6 weeks.
Yes.
Okay. I have
All right, let's do the motion to strike.
Okay, so the Hurt team has
Is
rested
more
their
entertaining
case.
in
Now
terms
it's a
of the
motion
outcome
to
than
strike
last time.
her
I
defamation
think it's
claims.
just gonna be oral arguments.
Oh, Godzilla Ben Chew. Here we go.
Yes, sir.
Good morning, Your Honor. May it please the court, Ben Chew for plaintiff Johnny Depp. Mr. Depp hereby moves to strike defendant Amber Heard's counterclaims because Ms. Heard has not proven by clear and convincing evidence that Mr. Waldman made the 3 allegedly defamatory statements with actual malice.
Right, but clear and convincing is not my motion to strike standard.
Understood, Your Honor. And
Okay.
we have cited the
Okay.
standard in our brief.
Thank you.
Moreover, Your Honor, the court should also strike defendant's claim for immunity and attorney's fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute. Because we know that the court has carefully reviewed our motion papers, I will just
You're right,
hit some of the
Lori.
salient points.
Absolutely right.
Thank you, Your Honor.
Please do.
I would mention,
Don't waste my time.
however, Your Honor, that because this is not included in our brief, that there is no record evidence whatsoever that Mr. Depp even saw any of the 3 statements that Mr. Waldman made prior to being served with the counterclaims in this action, which we believe is relevant to many of the legal standards. And as Your Honor is
true.
aware, Ms. Heard had signaled for the past week that she was planning to call Mr. Depp in her case in chief, and it was our anticipation she would try to fill what we believe is a gaping hole with respect to the elements of her proof. Again, there's no record evidence whatsoever that Mr. Depp ever saw any of the 3 statements about which Ms. Heard purportedly suing him for $100 million. As Your Honor is aware, the elements of defamation are as follows. 1, publication. of 2, an actionable statement, with 3, the requisite intent. See Thorpe versus Sanders, 235, Virginia 476 of 2013. The requisite intent for defamation against a public figure is actual malice. That is, the statement must be made with knowledge that it was false or with reckless disregard of whether it was false or not. See Sanders v. Harris, 213, Virginia 369 at 372, a 1972 case. See also Jackson v. Hartig, 274, Virginia at 2019. Reckless disregard, as Your Honor is aware, quote, is not measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipsis. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. St. Amant versus Thompson, 390 U.S. Supreme Court, 727 at 731. Your Honor, the evidence shows that Ms. Hurd cannot prevail on her claim because she cannot and did not establish that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation and reasonably believed that the 3 statements he made were true. Ms. Hurd presented nothing to contradict that undisputed fact. Ms. Hurd has no evidence of direct.
I like that blue suit Johnny's wearing. That's nice.
Obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting that she has no evidence of direct liability and cannot prove actual malice by Mr. Waldman when making the 3 statements at issue. It is undisputed that Mr. Depp did not make any of the 3 statements at issue in Ms. Hurd's counterclaim. Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated, or otherwise authorized Mr. Waldman to make the statements at issue. There is no such evidence on the record that Mr. Depp directed or otherwise authorized Mr. Waldman to make the 3 allegedly defamatory statements.
By the way, for those of you who don't know, the jury's not in the room for
Indeed,
this
there is
portion.
no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else. For this reason as well, Your Honor, Ms. Hurd cannot meet her burden of proving that Mr. Waldman was acting within the scope of his employment as our agency on behalf of Mr. Depp.
Jury's not here.
Again, it bears noting that there's no evidence that Mr. Depp even saw the statements by Mr. Waldman until he was sued, served with the counterclaims well into this case. It was more than a year after Mr. Depp filed his complaint, and Ms. Hurd lost a series of motions to dismiss that she finally asserted her counterclaims, most of which
I
were
think
already
the judge
dismissed
should,
by opinion letter of the
Lori, but
Whereas
I
here,
agree with you.
there is
I don't
no
think she will.
evidence of direct liability, Ms. Hurd must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions or statements, rather, of his purported agent, Mr. Waldman. Vicarious liability is, by definition, quote, liability for the tort of another person, unquote. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Hurd must establish that Mr. Waldman himself committed all the elements of defamation. I know the court's familiar with this, so I'll try to run through it quickly. Parker versus Caroline Clinic, 296 Virginia 319 and 332, a 2018 case. Quote, vicarious liability is liability for the tort of another person. It necessarily follows that a claimant cannot make out a case for vicarious liability.
those who are watching, please go ahead and like the video on Facebook and YouTube and share it. I appreciate it. Thanks.
See also Roughton Pontiac Court versus Alston.
If you're not subscribed to my YouTube page, please do so.
Page 156. Which standard Ms. Hurd has not met? And Your Honor, we cite a string citation to cases from other jurisdictions, which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is Ms. Heard's burden to prove by clear and convincing evidence, or ultimately, to prove actual malice by Mr. Waldman, not Mr. Depp. And while it is well settled law in Virginia, as Your Honor has pointed out last week, that an agent's knowledge can be imputed to a principal, and this is the Allen Realty Corp versus Holbert case, 227 Virginia 441 and 446. Ms. Heard's counsel cannot cite any case law stating that a principal's knowledge is imputed to an agent. In other words, Mr. Waldman must have made the statements knowing that they were false or with reckless disregard as to whether they were false.
Ben Chu is so good. He's really good.
There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false. Indeed, Mr. Waldman did not even know Mr. Depp or Ms. Heard at the time of any of the alleged incidents at issue, and thus had no personal knowledge of what transpired. And this is reflected in the trial transcript that Mr. Waldman met Mr. Depp first in October of 2016, long after the fact. Nor is there any evidence in the record that Mr. Waldman subjectively entertained any serious doubts about the falsity of the counterclaim statements. Quite the opposite. The evidence shows that it's unrebutted that Mr. Waldman had very reasonable grounds to believe, and he did believe, and will to his dying day, that Ms. Heard's claim of abuse were patently false. Mr. Waldman testified at length about 29 witnesses he believed disproved Ms. Heard's false claims of abuse. See the transcript at page 6008 through 6012, and I won't run through all of that. But his testimony that two trained police officers, Officer Sines and Haddon, were called to the penthouse on May 21, 2016, and saw no signs of injury on Ms. Heard's face, as well as, quote, Ms. Heard's own witnesses who have testified in various forums at various times that there were no injuries to her face whatsoever between May 21st and May 27th, 2016, when she walked in to court with her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of the witnesses whom Mr. Waldman has cited, they include Laura Devenier, Melanie Iglesias, who, as Your Honor recalls, was Ms. Heard's makeup artist, who decided to end any professional or personal association with Ms. Heard. Samantha McMillan, Hilda Vargas, Isaac Baruch, Trinity Esparza, Cornelius Harrell, Alejandro Romero, and Brandon Patterson, just to name a few. No reasonable jury could find that Mr. Waldman acted with actual malice in making the allegedly defamatory statements. He was not present for the alleged incidents. He has no personal knowledge of any of the alleged incidents. What Mr. Waldman knows is a product of the legal work he did, the sleuthing he did on behalf of Mr. Depp. Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice, and her defamation claim must fail. 2, Mr. Waldman is an independent contractor, not an employee. It's axiomatic, Your Honor, that a person who hires an independent contractor is not liable for the independent contractor's actions. See Sanchez versus Medicorp Health System, 270 Virginia, 299 at 3.
Wow, he's citing Virginia.
An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way to bring about that result. See Atkinson versus Sachno, 261 Virginia, 378 at 284. That's a 2001 case. An outside lawyer retained by a client in connection with litigation is an independent contractor, C. King versus Dalton, 895 F. Sub 831, Eastern District of Virginia, 1995, where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic applies when it's an individual like Mr. Depp.
Mhm.
That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results or to try to obtain specific results, but they do not control the means by which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject to professional obligations to exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing the client, a lawyer shall exercise independent professional judgment, unquote. Mr. Waldman is, as a matter of law, an independent contractor, and Mr. Depp cannot be held responsible for any alleged tort by his attorney, particularly.
I like that independent contractor angle.
He was unaware until he was sued for that. Mr. Waldman testified, and it's unrebutted, that he has his own law firm.
It's going to be interesting to see what
Depp.
Amber's
Mr.
team
Depp
says in response.
Or none of his loan out companies have issued him a W-2. And Mr. Waldman provides legal services to clients other than, in addition to Mr. Depp. And that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Hurd. Mr. Waldman's statements, the third reason for which we respectfully submit the counterclaim should be stricken, is that Mr. Waldman's statements were protected opinion. And I won't run through all of that, but very briefly, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment. See Gertz versus Robert Welchink, 418 U.S. 323 at 339. That's a 1974 case from the United States Supreme Court. See also Shacker v. Bufault, a Virginia Supreme Court case found at 290 Virginia 83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, unquote, and finding in an accusation of deceit to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp, Mr. Waldman was, to challenge Ms. Hurd's version of the inherently controversial events of the party's marriage. Just as Ms. Hurd's lawyers were quoted challenging Mr. Depp, and Your Honor will remember the context.
Hi, Roger. Welcome. Thanks for watching with me.
British tabloid, where Mr. Waldman's statements were buried well into article in which both points of view were clearly expressed. And Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as one of Mr. Depp's attorneys. C. Chavez, 230 Virginia 112 at page 119, quote, the most unsophisticated recipient of such a claim, i.e. any reader of the British tabloid, made by a competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, unquote.
Nice.
Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view about events that he never claims to have witnessed. And there was no doubt about that.
Many of these are arguments. That
Turning to the second
why
part
shouldn't have
of
gotten
the
here in the first
argument,
place.
which will be more abridged, Ms. Heard is not entitled to anti-SLAPP immunity. As a threshold matter, Virginia Code Section 8.01-223.2, which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019, provides in relevant part, quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. Here, in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries, marks, bruises, etc. Such witnesses include, but are not limited to, Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, Officer Sines and Haddon, Officer William Gatlin, and former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are not solely relating to a matter of public concern, as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed, and Ms. Heard put her name to it. What he is suing about here are the three statements that were directed at him. He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU, and he made it also to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion, but like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here. And I would object because I think making an argument not to you, but to the cameras, it threatens, it's disrespectful to the court.
on.
And everyone's
Seriously.
Get out of here.
Wow,
the
that's
integrity of this process.
Overruled,
and the
Chu
risk.
is
Your
crushing
Honor,
it.
I don't like
outside
the way that
matters.
this looks to the public.
Thank you.
Thank you, Your Honor.
Get out of
As I
here,
was trying
man.
to say, what Mr. Depp
the
is
integrity
suing
of the
about are the
process.
three statements.
Well,
And
Yeah, let's talk
very
about that,
clear,
Ronborn.
despite the pious
So it
opening
actually
statement
does impugn the
that
process.
about the First Amendment,
That basically came down to, Your Honor, I object because this is devastating for my
and
case.
the emails that were admitted as exhibits, that the ACLU and Ms. Heard were conspiring to make it very clear that those three statements were related to Mr. Depp, because otherwise nobody had any interest in the article. And it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of
That's
any
true.
significance in terms of
They released the op-ed December 18th. Aquaman
and
was
to do
released
that.
on December
And
20th or
that's very
21st.
clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146. Instead, The defamatory implication at issue in each of the three statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard.
Nice suit,
Which
Johnny.
does not rise to the level
Nice suit.
of a matter of public concern with broader implications for
I like
society.
the suit tie combo.
beyond The two litigants in this
I'll probably
case
go a little darker
any
blue.
more than Mr. Waldman's statements. I mean, adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the three statements that they very intentionally,
Good morning, Harry.
very cleverly
Good to
put
see you
in
on, bud.
to make it clear the
How things in
implication that it was
Florida?
about Mr. Depp. They had lawyers from the ACLU working around the clock with Eric George
Nice one, David.
to be as clever about this as possible. And Your Honor remembers the testimony of Mr. Doherty about the consternation at the ACLU when they realized that USA Today and everybody else who read the article knew darn well that this was about Mr. Depp. This cannot be protected by the anti-SLAPP statute. It is a cynical runaround. And I think now that we have the undisputed evidence from the ACLU in the form of the testimony of Terrence Doherty, who was not only their corporate representative, he was their general counsel. He is a brainiac lawyer. They knew exactly what they were doing, Your Honor. And he referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Heard, and he expressed no concern about that. Now, that was either because they knew about, that was either a reference to this game they were playing with the op-ed, or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way. Simply stated, Your Honor, Mr. Depp is not suing Ms. Heard for making statements about society in general. I think that's very clear from the record evidence. Mr. Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name. An act that, coming from an
Good grief.
ex-spouse,
Welcome.
is
Thanks for joining us.
personal in nature.
Harry the Greek, check him out. Phenomenal analysis
Is not applicable. And based
and
on the
professional handicapper.
foregoing, Your Honor, Mr.
You
Depp
definitely want to watch when it comes to sports. He knows his stuff. You got to check Harry out.
Motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much.
9.7 out of 10. Crushed it.
Solid lawyer.
Yeah.
How you argue a
Let's see what he has to say.
Thank you, Your Honor. As Your Honor knows, the trial court is required to accept as true all the evidence favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom, which would sustain the counterclaim. That's the correct standard here.
That's what he's going to do. He's going to say, well, Your Honor, even though we don't have a case,
Your Honor,
you should
there's
leave this up
plenty
to
of
the
evidence
jury
in the record
to
from which
decide.
The jury could determine that Mr. Waldman was Mr. Depp's agent. He made those statements. The statements referred to him as Mr. Depp's attorney.
Amen,
As Your
brother.
Honor ruled on Friday with respect to the jury instruction conference, an attorney is an agent of his client. Mr. Waldman testified that he's been Mr. Depp's attorney since 2016. He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer question after question about that agency. So we
I don't
can't use
remember
that
him
as a
saying on
sword
Mr.
now.
Depp's behalf.
Mr. Chu puts a lot of emphasis on the fact that Mr. Depp allegedly didn't see the comments that were made that are the subject of the counterclaim. But as Your Honor well knows, whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with the Daily Mail with Mr. Waldman prior to the defamatory statements being made and released. I believe that was in February.
I don't remember seeing that
2020,
evidence
just 2
either.
months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD. He disregarded any evidence that he didn't believe would fit in his narrative, that would fit in this story that he was speaking about on behalf of Mr. Depp. And after Mr. Depp lost the UK proceeding, after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding, the court there found him to be a wife beater. Mr. Waldman then got an overseas tabloid to run a story claiming that Amber was being investigated for perjury, which simply wasn't true.
By the way, the
Walked into
court did not
LAPD,
find him to be a
filed
wife
complaint
beater.
for
That's
perjury
a
against Ms.
lie.
Heard,
The lawyer should
found
be
a
ashamed
media
of
outlet
himself.
that doesn't follow the two-source rule, and then he had let the
A
world
little more
believe that the
complicated than that.
LAPD was investigating Ms. Heard for perjury. That's a shameful and a sickening example, Your Honor, of the lengths that Mr. Depp, through his agent, Mr. Waldman, would go to smear and to defame Amber Heard, and that continued in the 3 statements in the counterclaim. Your Honor has heard evidence, I won't go through all the evidence, but Your Honor has heard evidence from Ron Schnell, who's traced the negative hashtags toward Amber Heard online associated with those defamatory statements, and noted the staggeringly high number of them that were associated with Mr. Waldman. Under the principles of the agent-principal relationship in Virginia, Your Honor, when Mr. Waldman made those statements, he was standing in the shoes of Mr. Depp. They are one and the same for the purposes
You
of
haven't been able to prove that.
as Your Honor discussed at
Check
length
the
on
acting
Friday.
notes of it.
You have not
Mr.
been able to
Waldman
prove
made
that
these
at all.
statements with actual malice. There's plenty of evidence from which the jury could infer that. And his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless disregard of facts that didn't support Mr. Depp, and his attempts to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor denied Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's marriage and still made the statements at issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the
You
jury
don't have any
can,
evidence.
and we believe will find.
You have not been able to
Um,
prove the
so,
connection.
Your Honor,
I've been
there's-
watching this
there's no-
trial while I'm
there's no
working
basis
or
to write
not.
a motion to strike
I've been watching
on
this trial
agency argument
every
on the
day.
actual
You haven't been
malice
able to prove
argument.
it.
The evidence shows that not only was Mr. Waldman Mr. Depp's agent, that the two of them conspired to falsely accuse Amber of creating a hoax and falsify evidence that they believed supported their theory and what they wanted to achieve. As Your Honor well knows too, I won't go through all the law, but both agency and malice can be inferred through circumstantial evidence. There's plenty of evidence in the record from which the jury could infer those. Moving on, Your Honor, to the independent contractor, the court's already rejected this argument, ruled that an attorney-client have a principal-agent relationship, and as Your Honor said on Friday, there's no evidence in this case of anything otherwise. As to the argument that the counterclaim statements are statements of opinion, the court has already found twice that they are not statements of opinion, both on January 4th, 2021, in its opinion letter denying Mr. Depp's demur as to the counterclaim statements, and at the motion for summary judgment hearing in March of this year. As the anti-SLAPP argument, the court again has already ruled at the March 24th.
Such a sleazy thing to say that the court in England found Johnny Depp to be a wife beater. That is a lie. That's a flat out lie. That was not the finding.
The court has already ruled that. Therefore, the only remaining
The
issue
English
for anti-SLAPP
trial,
is whether the intent
Depp was
element
suing
of
the
immunity
Sun
is met.
newspaper
As
for
we
calling him a
discussed on
wife
Friday,
beater,
the intent
and
element
the
of
court
immunity is
found essentially
substantially
in the
the same as
Sun's
the actual
favor
malice standard,
that based
which,
on the
the
information they
evidence in
had,
this case,
completely different trial.
easily
It
allows
was
the
a
jury
judge-only ruling. The judge
to
was
find
an
in
idiot.
favor of Ms. Heard on
That
that.
the paper
I won't
had
go through
reasonable
the
suspicion
litany of evidence
based on
that
all the stories
supports,
that had come out.
that Mr. Depp is an
They
abuser
didn't
here, but I'll
rule
touch
he
on
was a
a
wife
few
beater.
things that relate to Mr.
Sleazy
Chu's
lawyer
argument. One, Mr.
tactic.
Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring.
The ACLU said they conspired.
To Mr. Depp.
Am I being
That's
gaslit
simply
right
not what Mr. Doherty said.
I think
Mr.
that's someone
Chu's
else's
field
misrepresentation.
He's laughing.
That's not what his testimony
The
reflects.
ACLU admitted they
Your Honor, there's
conspired.
also
Get more
Right,
Depp
right
in there
now.
to get it picked up by places like the Post.
Plenty of evidence
Yeah.
that's been
Make it more
adduced both in Mr.
impactful.
Depp's claim
That was
and
the
in Ms.
word.
Heard's counterclaim that show that absolutely that the counterclaim statements are 100% false. There was no hoax perpetrated. Mr. Depp is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, some of the evidence that's come up since the
I mean,
last
he's gotta
motion
say
strike,
that.
Your Honor,
Their
that
case
Mr.
is so
Chu
weak.
conveniently
He's gotta
used
say
in
that.
This brief or the testimony of Rocky Pennington, the testimony of Josh Drew,
Stupid.
testimony of Elizabeth Mars, all of whom completely corroborate Ms. Heard's account of the events of May 21st, 2016. The testimony of Melanie Iglesias, who
Do they know?
Testified that she covered Miss Heard's bruises with makeup right after the December 15th incident, that provided ample testimony to support that Miss Heard often would cover her bruises that were caused by the plaintiff in this case. By
Yeah,
Mr.
Jeff,
Depp
welcome.
with
Good to
makeup.
see you.
He ignores
And
the evidence of Christy Sexton. He ignores the evidence of
he's trying.
Wright.
He's
He
trying.
ignores the evidence of Whitney Enriquez. All of these witnesses and others have testified extensively about Mr. Depp's abusive behavior toward Miss Heard. Physical abuse, emotional abuse, psychological abuse, verbal abuse, Your Honor. Mr. Depp's own writings,
Seems like
recordings,
Ben decided what's
pictures,
good for the
and
goose is
videos
good for the
confirm
gander.
that. The list goes on. There's abundant evidence in the record, Your Honor, from which the jury could, and again, we believe will
By the
find
way,
that Miss Heard is not liable.
there's
for
no
defamation
writings that
against Depp.
Johnny
And
has
therefore,
that
by
have been
definition,
identified in court, to
she
my
is-
knowledge,
she
where
has
he
not
admits to
acted with
abusing
actual
her or beating
malice.
her.
And based on
None.
the court's rulings on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court to award attorney's fees against Mr. Depp. So with that, Your Honor, I'm happy to answer any questions the court has.
That's
but
fine.
that
Thank you,
covers
sir.
it. Thank you.
Yes, sir.
Do you know
Your
how to
Honor, I
spell
will be
strike?
brief in deference to the court's
That's a
time.
The
and
judge
jury's time.
should strike her motion, but she probably
What
Wells
won't.
Fargo
Mr.
number 2.
Rottenborn
Thank you.
said
Very, very generous.
about Mr. Waldman's allegedly going to the LAPD about perjury is a complete non sequitur. If they thought that that
It's not
was
on the record.
somehow improper conduct, they could have included it in their counterclaims. They included everything else but the kitchen sink, and most of it was thrown out. There was nothing in there about Mr. Waldman going to the LAPD. So that
Yes,
is
I'm
a
looking forward to that
very
too.
clear non sequitur, red herring distraction. Number two, when Your Honor ruled on summary judgment on the issue of the counterclaims, Your Honor was dealing with a different standard and a different evidentiary record. At that time, Mr. Waldman had not testified, which is material. Mr. Waldman has now testified for purposes of trial. We have his trial testimony. It's very clear that he did not act with actual malice. They didn't even argue that. So that's pretty clear.
You have no agency connection. You gotta hit agency.
And again, this is consistent. The third point is that it's all about games. They didn't sue Mr. Waldman on the 3 statements. They didn't try to fill the hole. They've been telling us for a week that they're going to call Mr. Depp to try to fill the hole in their counterclaims. They didn't do that. And it's very consistent with the game plan. Let's go into court after the police have found.
You should, brother. It's really good.
And after witness who have no relationship with each
I'm
other.
hoping the judge strikes. Hoping she strikes the counterclaim.
For the required 24-hour notice before the TRO.
But she's pretty conservative as far as the way she's been leading this whole proceeding. I don't think she will. I think she'd
Let's get a
rather
TRO.
toss it to the jury.
And when the Me Too folks say, why are you taking $7 million from an abuser? They said, I didn't take money from the abuser. I gave it all to charity. Well, they didn't. I don't think anybody should feel bad about them stiffing the ACLU, given what the ACLU did in this case.
Nice.
Monstrosity. But she did
Hey,
stiff
Kim,
the sick and dying.
welcome.
So it is
Absolutely.
games.
Justice for Johnny.
And that's what she's doing here today. But the law is the law, and they have not fulfilled
He's
their
not wrong.
burden
That's
with
right.
respect to the counterclaim.
It just doesn't have
There
much
is
to do with this motion.
virtually no
Yeah.
nexus between
That's
Mr. Depp and Mr. Waldman as to these statements at issue, except for the fact that he is an attorney, and that is not sufficient in a case where they have not even established that Mr. Depp was aware of these statements. And they knew that they couldn't do it, and they didn't even try. And it's more of the gamesmanship when Ms. Heard plays word games with Mr. Depp about, oh, I didn't punch you, Johnny, I just hit you. Imagine if the shoe were on the other foot and Mr. Depp, a man, was saying to a woman, oh, woman up, I only hit you, I didn't punch you. And when it was chilling, when she warned him on the tape, you go tell a judge, you go tell a jury that you, a man, were abused. See if they're going to believe that.
Practicing his closing?
A little bit.
That's
It is
exactly what she
abuse
said.
of the system, and she's done it throughout. Finally, Your Honor, and Mr. Rottenborn makes an excellent point with which
I agree.
which was that with respect to each of the three statements, Mr. Waldman was clearly identified, even by the tabloid that printed these, well within articles that had both sides represented, that he was Mr. Waldman's attorney. Even the reader of a tabloid understands that when you're getting statements from attorneys, it's going to be forwarding their client's point of view. Mr. Waldman is not the only attorney who has spoken out. Robbie Kaplan, who was Ms. Heard's second attorney. So Ms. Heard started out with Eric George. He made comments to the press.
Objection, Your Honor. Again, this is so much further beyond what Your Honor is addressing.
I'm finishing up.
Okay.
I'm finishing up. My point, Your Honor, and it's on point, is that Mr. George made statements supporting Ms. Heard's position. Ms. Kaplan made very clear statements supporting her client's position on the merits, and so did Mr. Waldman. But everybody knows when reading those that those are statements by partisans. So for the reasons that you stated and the reasons set forth in the brief, we respectfully submit that the court should grant the motion to strike, or in light of the fact that Mr. Depp may reappear, at the very least,
Do you think the judge will strike the motion? Let me know, yes or no.
Thank you, Your
All
Honor.
right, thank you, sir.
I think you should
All right, in
wait.
this matter, I've reviewed all the defendant's evidence as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are outside the motion to strike, and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered in the motion to strike. Having said that, we went down that legal road on Friday as far as the slap defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there's evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to waive the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the three statements that are issued in the counterclaim.
Going to the jury.
Ruled
That's all
that
you
they're
need.
not opinion at the demurrer at summary
Sure,
judgment.
yeah.
So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may and usually are relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship, is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail Online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay.
I knew it.
Thank you.
And if she's going to deny it.
Even if I would disagree with it.
Yeah.
Okay.
I mean, I can track it. It flows.
She's wrong on agency. You tell me how the jury's supposed to determine what the scope of his agency is with no proof.
Exactly.
I completely agree with that.
I mean, yeah.
It's bullshit. She punched it to the jury so she doesn't have to think about it, so she can get that blessing. But how are they going to evaluate the scope of the agency?
That's exactly
They
right.
can't. It's entirely speculative.
Yeah.
It is.
This
It
is a fair
absolutely is.
point.
Okay, so just as a little bit of a recap for folks that are confused about what that was. This was the motion to strike Amber Heard's counterclaim because Amber Heard's side, they have rested their case in chief. They have no more witnesses that they will be putting on. God bless. And so now we're going to be going into the rebuttal after this. But the question was whether or not they could strike Amber Heard's counterclaims on the basis of the evidence
Unfortunately,
that she
she
provided.
didn't strike it.
The issue here in particular was whether or not Waldman's statements can even be connected to Johnny, whether you can attribute his statements to Johnny, because as a default matter, the things that we do as individuals cannot be put against somebody else. In other words, we can't be held responsible for what somebody else does that is wrong under the law, except for under certain circumstances. You have to have a special type of relationship in order to be able to put somebody else's bad act onto another individual. Vicarious liability is the term for that here that is the main issue. And it has to do with Adam Waldman having been the lawyer for Johnny, being the agent for Johnny, who is the principal. So it's principal-agent kind of relationship. So the issue here was there even enough information that a reasonable jury can even look at the evidence here and say, yeah, we think that there's enough here that Johnny probably directed Adam Waldman to say the things that he did that were defamatory. The judge has determined that you can do that with inference through circumstantial evidence. So, and this case law does suggest that inference, you can get there with inference, you can get there with circumstantial evidence, but the judge here says that there's enough circumstantial evidence here, a scintilla of evidence. It means like there has to be like a tiny little speck, tiny little dust speck, essentially, that a jury could look at in order to make that determination. We disagree with that because everything about those communications between Adam Waldman and Johnny Depp has been barred by the attorney-client privilege. There's no way that anybody can know what those communications were. How do we know that Adam Waldman didn't just go rogue on Johnny?
That's Amber Heard's
and just
sister
go
that's
off
shown
and
on
say
camera.
things that Johnny didn't actually want him to do, that were not in his interests, that were not, you know what I mean? So
Yes,
there's a
I know
lot
she
of
looks like a
reason why.
transgender.
And as for
It's
the
mean,
actual
but it's true.
motion to strike, so it doesn't consume any testimony time. So the 8 hours, the 4 hours, 18 hours that are left on either side, it's not, that has nothing to do, it's not chipped away at by either side through this motion to strike. Can you object on rebuttals if you run out of time? I'm going through some of the questions.
Before anybody asks me,
on Super
no,
Chats
she's
really
not
quick, 'cause I know that
transgender.
we've got
That's her
quite a few of
actual
them.
little
Can
sister.
you object on rebuttals if you run out of time? Yes. What happens if Amber Heard runs out of time under Virginia law, and what is an appeal issue? So if she runs out of time, we talked about that earlier. If you want to, go back about maybe 45 minutes or an hour from this point, and you will see a fantastic discussion led by Andrea. She had some really great points there. So go back and check that out. But basically, there's a chance that the judge could give a 5-minute cross-examination under those cases because or under this situation to make sure that she doesn't give rise to an appealable issue, because that could be potentially an appealable issue under Virginia case law. Now at the same time, she also has the ability to keep the rules in her courtroom, reasonably speaking. Okay, and then let's see here.
So it sounds
Is there an
like
appeal issue that
Alita
could
is
be an appealable
saying,
issue? And then the jury was not present for the motion to strike argument, because that is all legal
Right.
argument. That's all going to be stuff that could potentially sway a jury improperly. They don't necessarily understand what's going on, so it's improper for them to be there. So they were not there for that. And then is the jury aware of time limits? I don't think so. I believe every time that
it sounds
judge
like what
who is
Alita's
Friday
saying is
has
that
updated everyone on their time
even though
limit
Amber's team
after the
only has
jury has
4
left.
hours left,
Yeah.
which is why they
So
rested their
I don't think
case,
they have
and they
any
want to waste
idea
any more
about
time.
those time limits.
They only have
Okay.
4 hours left for the rest of this week until
Impressions
Thursday.
from the motion
They
to strike,
didn't
folks.
want, she
Well, I
may
think
offer
actually
them
for Zach,
extra time
this
to
is
do
where
a
his strength
cross,
is.
which I think is bull.
And
That's
I really
bullshit.
like the way he presents things in terms of his legal argument. It's like listening to a brief, and it's well sourced, well cited. It flows well. So this is a strength for his. He's like parallel to Vasquez, where Vasquez is good on cross. He's really good at this part of like the argument. So it goes to show his strength. I kind of agree with Richard a little bit on the question of, is it speculation or is it inference? Is an interesting
Right.
question in terms of the nature of the agency or the scope of it. Richard thinks speculative. I think there's a reasoned case for that. I think depending on how generous we want to be, there's a reasoned case for inference. So while I think I would disagree with the judge, I couldn't overrule her if I were in a position to do so. I think her judgment's within the bounds.
I think it's definitely within the bounds. And I think the chat needs to understand that like the vast majority of these are going to the jury. By the time you get to this point in the trial,
Exactly,
the
Lori.
fact that I thought it was 50-50
Exactly.
was hugely high for something like this, because I just don't think they proved an agency relationship at all. And that's the problem with reading between the lines in the lawyer. The other thing I would point out, and I don't know what this judge's background is there is no question in my mind that a lawyer serving in Adam Waldman's capacity, which is effectively Hogue Law capacity, is an independent contractor. We talk about tasks, and I go off and do my thing, and then we talk with clients. There's no way in hell I'm an employee of my clients.
Correct.
And so I would have taken that more closely. Essentially, what the judge said is lawyers are special, and to my mind, if lawyers are special the other direction. That there needs to be more deference to commentating on your clients.
Also, Hyatt, thank you for the very generous super chat. Says this means the jury will analyze and see if 1, the statements made by Waldman can be attributed to JD, and 2, is defamatory to Amber. Does this mean for JD to win, Amber has to lose her countersuit?
Not theoretically.
Practically speaking, it would be very inconsistent for both parties here to win. And the reason why is because they would have to each show that the other side made a false statement. And so it would be difficult for Johnny to make a false statement about her committing an abuse hoax while she's also making a false statement about him being an abuser. This is just kind of one of the peculiarities of this case.
It's going to be one or the other.
Factually,
but I'm going to get back to something Lori said. You're absolutely right, Lori. It's not the Johnny Depp team's fault that they have 16 hours left of testimony and the Heard team only has 4 hours. The Heard team misused their time. So for the judge to say, well, where it looks like she may lead towards is giving them 5 minutes to do cross-examinations on Johnny's people, that just seems wrong. But I guess this judge, like I said, she's very ginger when it comes to her opinions as far as wanting to be too involved, which is why she didn't strike the motion, which she should have. Because as you're hearing the lawyers saying right now, they did not prove, the Heard side did not prove that Johnny had anything to do with the 3 statements that his attorney made that were considered derogatory towards Amber Heard. Never mind that they were true, but considered derogatory towards Amber Heard. And giving them extra time and they used up all their time is just, that's bull. That's crap. I'm with you, Lori, on that.
After argument. So that argument was just for the record and show, effectively. And as attorneys
very good point, Mike.
It doesn't bother us. It's just the way it is.
You never know. Someone could say something she hadn't thought of, but
Hail Mary.
This is often what happens in litigation when you have a motion hearing in any kind of a case, whether it's at trial or pre-trial. you oftentimes a judge will issue a preliminary ruling, so you'll know going into the hearing basically what the judge's thoughts are, like
Get
whether
some
whether the
coffee,
judge is
some
thinking
more
with
coffee,
you
or
or
warm up
against
my
you, and
coffee
kind of like
rather.
what
I'll be right
your
back.
what your roadmap has to be going into this hearing, how you have to convince this judge either to turn the ship around or to continue going down a certain path. So this is it's incredibly common for her to have essentially made up her mind before, but still listen to the arguments to say like, okay, this is nothing that you've said here has been particularly convincing. And Andrea, correct me if I'm wrong, but Ben Chu's arguments that he gave, they sounded like they were pretty much all the same as the arguments that we heard in the motion for summary judgment on these issues going into this trial also.
Yeah, they really were. And frankly, this is a good legal argument. I would expect that if Amber Heard achieves some miracle and wins a verdict in this case, that Johnny would appeal on those grounds. It is a question of legal interpretation as far as what is required to prove agency in this particular type of relationship. Also, this question of whether Adam Waldman has to be shown to be acting with actual malice, or can, Johnny's intent somehow be imputed to him? These would be very strong issues on appeal. So he is consistently raising them again and again to make sure that he's preserved them and to make sure that the judge has had ample opportunity to be able to consider those and rule on them. So
Yeah.
yes, they are essentially mirroring the arguments that he made in those earlier proceedings. The difference is just that there are different standards applying depending on what stage of the process that you're at. At the summary judgment, it's based on what evidence essentially could be available to come out at trial. At this point, we know now what actually has come out at trial. So just a little bit of a different way of looking at the same question.
Right.
Well, that's why Chu was so wise to say, you saw the Waldman deposition. That was the big key. They got nothing.
Yeah.
Mm-hmm.
Yep.
Yeah. And that honestly was his best argument to make. Time out question. It's also, thank you for your generous super chat. Says, can JD take the agency issue to appeal if the jury finds for Amber's counterclaim?
Yep.
Yes.
Yes.
That's
Yeah,
exactly
but
why you bring it.
yes, exactly. The only issue with that is that her reasoning was actually pretty decent. So, how successful that would be, I don't know. Even
Appeals
if
are
we
very
disagree with, even if we ultimately disagree with what it is that she concluded, it's not well, yeah.
Judges
What else?
Her reasoning was pretty decent.
I could see an appellate court saying, no, jury shouldn't have seen this. They hadn't established agency.
Yeah,
I'm not saying
and
they
what I'll
would, but
say
it's possible.
about this
Sure,
issue that
sure,
I think
possibly,
makes
yeah.
it a lot stronger than a lot of appeal issues. A lot of possibilities people have mentioned concerning the rulings on the evidence and things along those lines. Those are very discretionary rulings with the judge. So those are reviewed under a very unfavorable standard to the appellant. They basically have to show that the judge was acting entirely unreasonable. This agency question is a pure question of law. It's what does the law require? It's what does the law require in terms of the evidence that has to be brought? So that is one where typically the Court of Appeals does not have to give any deference to the trial court. They're going to consider that independently and review it what they call de novo. So just from a pure standpoint of what is a good appeal issue to work with, this agency issue is a much stronger issue than certainly any of the evidentiary rulings that we've seen made so far.
Agreed.
Well, I think it all boils down to we wanted a different opinion, we wanted a different decision. There was a possibility of a different decision, but nobody's surprised by the decision. Right.
Yeah.
I think the weakest part of her analysis is the agency issue, because as Chu himself noted, and as I also kind of myself noted as I was trying to speed read through Virginia law yesterday, it does seem to be true that attorneys are treated as independent contractors rather than employees. See, this entire argument doesn't work if he's an independent contractor. He has to be an employee. So the law seems to suggest against that. So the judge's reasoning appears to be something along the lines of he worked on a lot of different matters. So he wasn't just employed as an attorney for one issue one time. He was employed as a lot of issues for lots of times. And so that transforms what might be a series of independent contractor roles into something more, which I don't know if I buy that argument, but okay. So that's the weakest part of the analysis for me.
From my standpoint, the thing that I really find problematic in how this issue has been fleshed out in the court is the open question about what are the jurors going to be allowed to do with Johnny's invocation of the attorney-client privilege. The very fact that she allowed that to be played in front of the jury suggests that she is treating it as something that's relevant, that's something they can take into consideration to evaluate, well, does that mean Johnny had something to hide? Does that mean that this would have gone against him had Adam been allowed to answer these questions? And this is really concerning, I think, to me and to probably most practitioners, because we do see being able to consult with an attorney as something that's important and kind of sacred.
That's a
you
good
have
point.
to
I wonder
be
if they
able
get a
to-
jury instruction on that.
I think
Well,
they will.
Yeah,
it's
they
sort of like
should.
it's sort of like you
I
can't
hope
hold
so.
the Fifth Amendment against somebody.
I think they'll
Yeah.
get a no negative inference jury instruction. Are you watching the judge with the full hand here? I wonder if
Yeah.
this isn't them discussing the time.
Yeah, it could
Probably.
be.
She is
By the way,
animated.
T in Tennessee, thank you for your generous super chat. Says, question, I didn't know home insurance could pay legal fees. How does that work? Is there any chance JD's team will rest early? I'm not sure where this home
Homeowners
insurance
because
thing is coming from.
it's been speculated that Amber's legal fees are being paid by her own homeowners insurance policy.
Well, if
So-
you get sued, for instance, like I have like dog bite cases all the time, which will fall under homeowners policy, and they have a duty to indemnify and a duty to defend. So yes, they'll hire an attorney for you, but I don't see where this is applicable to a homeowner's policy.
Unintentional tort?
Right.
Typically,
Yeah.
intentional torts are not going to be covered by
Yeah,
a
yeah.
homeowner's insurance.
It would have to be
Absolutely.
one of these
Yeah.
Hollywood super specialized high premium.
But that's the thing.
Types of
Yeah,
insurance.
you don't know the actual policy that you're referring to exactly.
Sure.
Yeah. This doesn't, there has to be some sort of a relation to the home.
Also, your
You know, like-
umbrella policy may
Does she
also
have
help.
a
Check with your
home to
agent.
have homeowners insurance on?
Yeah. I
no,
don't know about that.
I deal with this a lot. I do civil stuff. The duty to indemnify is more narrow than the duty to defend. So a lot of times, insurance companies will say, send your attorneys in to defend them. You may not have to pay, but you got to defend them. So it's a very broad duty, just generally speaking, in that context.
Yeah.
Now,
yeah.
so then would they seek reimbursement from her if it
Did you
turned
see that?
out that she
What was
doesn't get
Yeah, what was that
I
smile over
guess.
there?
She goes, okay, so the judge goes this and then goes like this, and then Ben turns around and smiles. That is what happened.
Yeah.
Doing a little
Hmm.
hokey pokey over here at the bench.
I can't believe we're
Interesting.
nerding out at this level on YouTube right now. Honestly,
This is pretty bad.
I love it. I love it.
Does that mean the
But,
judge
but
isn't going
also,
to give
I
them
wanted
extra
to address
time?
One thing that I've
Wonder.
gotten a lot of questions. I'm sure you guys have all gotten questions in your DMs and your
They
mentions.
shouldn't get
and-
extra
and
time. They used up
emails
their
and stuff,
time.
about this hot mic, I guess, that we could kind of hear yesterday from Dr.
Oh.
Spiegel just before he testified. Now, there has been a lot of speculation as to whether he asked if he could lie on the stand. I highly, highly, highly doubt that was the case. Number one, asking that outright is not a good idea. Not very smart for somebody who's. Yeah, I mean, we could all have our opinions as to his
Are
intelligence
you all
level, but
taking notes about a goddamn criminal conspiracy?
yeah, but also for him to do that in court when he knows that there's cameras in the courtroom, there's a lot of people, a lot of supportive people for Johnny Depp around him. That would not be a good idea. That doesn't necessarily mean it didn't happen. However, my impression is that he probably said, not can I lie, but can I rely on testimony
Whatever.
or
Yeah.
something along those lines? So I know that it's so easy in this case to hear hooves and think zebras, but very often it's more the case that you hear hooves and it's going to be a basic horse.
Nice Scrubs
So
reference.
even as unimpressive as Elaine may be.
Sorry, Jeff.
Yeah.
If you're a witness
no
says,
way.
"Can I lie on the
Next
stand?"
time.
You say,
Next time.
"Guess who's
Yeah,
not
sure, no
testifying
problem,
today?"
There's no way. Alita, I love how much you lawyered up on that because that's how we all talk about everything. I'm willing to guarantee that she did not say I'm going to lie.
yeah. Yeah, yeah. So
Where do I come
Schmeagol
in
yesterday was
flagging
hilarious.
I just yeah,
Okay, all right,
I
yeah.
wanted to address that because I know that
Yeah.
we've gotten a number of super chats on that, and folks have a lot of questions. So
I think I'm just happy we got a Wire reference and a Scrubs reference like right on top of each other. So
Yeah.
I'm having a good morning already.
I know. And I started the day with a bridesmaids reference. It was great. So
Yeah, I missed Bridesmaids. All right.
yeah,
We'll
it was
get some
before
Harry
anybody
Potter
else
in?
was here.
All
Yeah,
right.
we'll get Harry Potter in, of course, always. There's
One
always
of
time
my
for Harry
favorite
Potter.
comments, I'll do it right now actually, halfway through the trial is it just me or do the last names of Johnny Depp's team remind me of the good Harry Potter houses and the last names of the Heard team remind me of the bad names of the Harry Potter houses? It's like, and I was like, I was originally going to dismiss this and I was like, Emil Vasquez and Ben Chu against Ben Rottenborn and like, you know what?
Yeah, it does sound like there's
You know
Slytherin
what,
versus
commenter?
Gryffindor.
Yep. Harry
It's
Potter
Smeagol
names.
Hiram against the orcs.
The good
Yep,
house versus
yep.
bad
Yeah.
house.
How much do you
So-
have to hate yourself to not change your last name at this point as well? I want to know.
What's Scrubs
They're
reference?
also
Well,
Dickensian.
I know the horses and
Yeah.
zebras from Scrubs. Alita might know it from somewhere else.
I give credit to
you-
Scrubs.
You know what? Sorry.
Someone asked where was the Scrubs reference. I said I personally know horses and zebras from Scrubs.
Yes.
I said okay.
Yeah. That's where I got it too. That's a great show. It's a really great show. Of course, none of us
Scrubs
are
was a great
doctors,
show.
so we can appreciate it. If there was a similar show about lawyers, I don't know if. Although I do love Arrested Development, and there are some very funny lawyers on that show.
Bob
Mostly
Loblaw,
because
blah,
they,
blah.
yeah, blah
The
blah
rest of
blah
the
blah
development
blah.
was
blah.
really funny. That was a very
Scrubs is my
funny
favorite
show.
comedy of all time, and I still associate that first year with one of the best depictions of being a young professional like ever.
Yeah.
You just hurled into things and like Rick, go read the red flags. It's like I don't even know what I'm looking at. How do you know what a red flag is when you've never seen a document like it ever before? But yeah, so I still think it's
my
Scrubs first
favorite
year.
was this would be a great job if it wasn't for all the sick people.
Great line. Herb.
We certainly never say that about clients.
If you haven't seen Scrubs, go watch it. It's hilarious.
Never.
It is
never,
hilarious. It's a
Never,
great
never,
show.
never. So anyhow, let's get some super chat questions here while we continue to wait. Do closing arguments count as time? They have time, but it's a separate time. It's not the same time as what we are calculating right now. So let me get another one. L says, how come Dr. Curry saw AH, but JD didn't see anyone? Also, hi to my new wife, Laura, just married. Congratulations.
Aw.
Congratulations. Of course, I say
I like
this
how
with,
my chat, my
Mr.
comment
Bites being
doesn't
in probably the other room.
doesn't
Happy wife, happy
interrupt
life.
theirs. That's
It's always a
cool.
good thing. I'm just kidding. Not always.
But yeah,
Wives
please
also have
like,
to
comment,
be
and
happy
share.
too.
Thank you.
It always, shoe goes on the other foot always. But but anyhow,
You don't always have to take
congratulations.
off boots, is the point, though. You can find a nice middle ground.
Yep.
Yes, of course. So anyhow, but yes, my greatest congratulations, and I wish you all the happiness together. And hopefully your marriage doesn't end up anywhere near anything like this case.
Oh God, I hope
Just
not.
like what all of
That'd
us
be
would
terrible.
want for ourselves. But also, why did Dr. Curry see AH and JD wasn't seen by anyone? It's because Amber Heard put her mental state at issue by claiming that she has PTSD as part of her damages for her counterclaims. So
Yep.
that is exactly the reason. When you put that at issue, it means that you are saying my brain is something that has been harmed here. The other side is able to come back and say, how do I know that your brain has really been harmed? I need to be able to check in there and discover that and poke and prod and find some holes in there. So so that's exactly what happened.
That's
Johnny
right.
Depp has not alleged PTSD as a particular harm, so he doesn't have to get the same thing. So didn't know if anybody wanted to add to
Very
that.
well summarized, Elaine. Elaine.
All right.
Alita.
James Walsh says,
All right, are we ready for the jury then?
all right, jury's going to come in. I'll do one more. James Walsh, what are the odds Amber initially wanted to settle this out of court with this legal team? They seem to be out of their depth in the
I doubt
courtroom.
it.
Maybe that isn't their forte. Are they past the point of no return? They have been past the point of no return for months and months and months, I think. I don't think, well, so number one, Amber would have had to want to settle. Number two, Johnny would have
That's
also
pretty much
wanted
the
to
end of that
settle.
analysis. Yeah, point number one, the client sucks.
Yeah. So I and in my opinion, it just seems like the kind of case where Johnny needed the truth to be out. So in order for him to agree to settle, it seems like the kind of case where he would have required her to come out with an apology, and there's no way, no snowball's chance in hell that would ever happen, according to the things that we have seen here. So, yeah, odds are zero, essentially.
Yeah, I don't think Amber
Abigail Ridgeway
has it in her
says,
to
question, do we
sell.
know anyone in the courtroom today? Yes, and we know that
She's
Larry's there.
been lying for
James,
so
I believe,
long.
also
She
got
believes her
in.
BS
I think
now.
Laura B said that. Real Laura B said that she got in there.
Good morning, ladies
And
and
Emily
gentlemen. I
just hit a
apologize. We had a few
$500,000
housekeeping
just now.
matters to take care of, but thank
Mhm.
you. You can have your seat.
Emily's
All
at
right, your next
500K.
witness.
Congrats, Emily.
She just did a $500,000 right now.
Amazing.
All right, thank you.
Amazing,
Rebuttal
amazing.
evidence?
Yes.
Emily
Your
Baker
Honor,
hit
Mr.
half
Depp
a million.
calls Walter Hamada of Warner Brothers.
All right,
Boom.
Mr.
Oh.
Hamada.
I'd be
Walter
happy to
Hamada.
get to 1,000.
Here we go. And then one last quick
Your
question
Honor, just to
here.
clarify, this is by deposition, so we may need
Oh,
that.
okay, listen to, okay.
I apologize, I should have provided notice.
That's all right.
Thank you, Your Honor.
Kim Sebs says, will Johnny be able to sue Disney for damages after this? No. Quick answer is no. And then also, hey, yeah, Walter Hamada.
Video
He's testifying.
deposition. Here we
You
go.
are correct in that. Am I going extinct after this? Hopefully, what if anything? And then here's a question from Dr. Indushri Rajan, the conscious psychologist. You guys have been insightful and entertaining. Thank you. Any thoughts on whether info regarding the UK trial and the impact of 2016 press impact on JD will sway the jury regarding the damages? Thank you so much. I'm watching from California. Awesome.
You see this note in the chat that Emily hit 500,000?
Yes, I did.
I'm sorry if we discussed that already. I might have passed out somewhere.
That's okay. We did, but it's okay. It's okay. We're all celebrating.
Well, I got
so
the
but to answer this really quick, if the UK trial could impact. It would suck. It's not supposed to.
What do you work for Warner Brothers Entertainment Inc.?
Yes, I do.
In what capacity?
My title is president of DC-based film productions for Warner Brothers.
What, if anything, you did to prepare to testify for Warner Brothers as to topics 2 through 18?
I did not do anything to prepare for this, other than the meeting that I had with the attorneys.
Did Warner Brothers have a contract with Amber Heard to perform an Aquaman 2?
Yes, there was we had an option agreement for her for Aquaman 2.
Do you know what it is?
It looks like a standard contract between an actor and the studio.
And which actor was involved in this? Which actor was a party to this contract?
Amber Heard. It's a contract for Amber Heard for the role of Mara in Aquaman and its sequels.
Which studio contracted with Amber Heard?
Warner Brothers.
When did you come to be the president of DC?
At the beginning of 2018.
Mr. Hamada, was Ms. Heard ever released by Warner Brothers from the Aquaman 2 contract, or what you call the option agreement?
No.
Was she released from her Aquaman 2 contract on or about February 22, 2021?
No.
Was Ms. Heard ever rehired for Aquaman 2 by Warner Brothers?
No.
So she wasn't fired, so there was no need to rehire her.
Did Ms. Heard receive a pay increase for Aquaman 2?
No.
Why not?
As a rule, as a company, we go through a lot of trouble when we make our deals with our actors. We get options on them for subsequent movies. And I think traditionally, prior to me joining the company, every option was renegotiated. And one of the things that we were trying to put a rein in on was not renegotiating every deal, with the understanding that people come in and make these deals and they have an understanding that there will be options and that there is a deal in place. And it was a big part of our philosophy that we were going to hold people to their options moving forward.
But did Warner Brothers at any point in time reduce Ms. Heard's role in Aquaman 2?
The role in the film the size of the role in the film that she has was determined in the early development of the script, which would have happened in 2018, I would say. So, and from there, beyond normal development, the role sort of, the character's involvement in the story was sort of what it was from the beginning.
Was her role ever reduced for any reason?
No, I mean, again, from the early stages of the development of the script, the movie was built around the character of Arthur and the character of Orm, Arthur being Jason Momoa and Orm being Patrick Wilson. So they were always the two co-leads of the movie.
Did Warner Brothers ever plan to portray Ms. Heard as the co-lead in Aquaman 2?
No, it was the movie was always pitched as a buddy comedy between Jason Momoa and Patrick Wilson.
Was Ms. Heard cast in Aquaman?
Yes, she was.
Was Ms. Heard cast in Aquaman 2?
Yes, she was.
Was Ms. Heard paid for her services in Aquaman 1?
Yes.
Was Ms. Heard paid for her services in Aquaman 2?
Yes.
Was her compensation for Aquaman 2 affected in any way by anything said by Johnny Depp?
No.
Was her compensation for Aquaman 2 affected by anything said by Adam Waldman?
No.
Was her compensation for Aquaman 2 affected by anything said by anybody representing Johnny Depp?
No.
Was there any delay in Warner Brothers exercising the option to cast Ms. Heard in Aquaman 2?
Yes, there was.
How long a delay was there?
I don't know, probably weeks.
What was the cause of the delay?
There were conversations about potentially recasting.
Who?
Who was the producer?
Peter Safran.
Who?
Who was the director?
Recasting.
James Wan.
Did Warner Brothers believe that those concerns were legitimate?
Yeah, I mean, I had no reason not to believe the director and the producer of the movie.
And you are testifying today as a representative of Warner, correct?
Yes, I am.
What, if any, creative concerns did Warner Brothers have about casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first movie, which is the issue of chemistry. Did the two have chemistry? I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get there. And would we be better off recasting, finding someone who had better, more natural chemistry with Jason Momoa?
Bingo.
Moving forward that way.
Bingo.
Did Warner Brothers take any steps affirmatively to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
Other than the creative concerns and concerns about chemistry you testified about, was there any other reason Warner Brothers delayed in picking up Ms. Heard's option for Aquaman 2?
Leonard,
No,
thank you so
it was
much
all,
for your
it was
generous
all
super chat.
concerns about whether she was the right bit of casting for the movie.
What role, if any, did
What, if any? I love that.
Ms. Heard's dispute with Johnny Depp have in Warner Brothers delay picking up Ms. Heard's option for Aquaman 2?
There was none from our end.
No dispute. Or
At any
didn't
point
play a
in
role.
time, was Warner Brothers considering paying Ms. Heard more money for Aquaman 2 than is set forth in the option contract you previously identified?
No, as I said, we're determined to hold our actors to their option agreements.
What this is about is Amber Heard's countersuit, where she's saying that the allegations that have come out have been hurtful to her career, including Aquaman 2.
Earlier.
No.
At any time from the beginning of history through today, did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
At any point in time from the beginning of history to today, did Warner Brothers rehire Ms. Heard for Aquaman 2?
No, because we just picked up our option.
And when is the last time you spoke with Rob relating in any manner to whether to exercise the option on Amber Heard for Aquaman 2?
No, it would have been the same time that I was having those conversations with Peter Safran.
So
in 2020.
Did you speak with Zack Snyder at all relating to whether to exercise the option for Amber Heard on Aquaman 2?
No, I've not had any conversations with Zack Snyder.
Did you speak at all with Jason Momoa in preparation for your deposition today?
No.
Have you ever spoken with Jason Momoa about any issues relating to chemistry?
Jason Momoa doesn't like Amber.
And Amber Heard.
Yes.
When did you speak with Jason Momoa about chemistry issues between he and
It would have been in that same time period where we were prior to green light of the movie.
Now, you were asked some questions about scripts. Did you review any of the drafts of the script for Aquaman 2?
Yes.
When?
I part of my role is I read all the drafts of the scripts as they come in.
When was the first script for Aquaman 2?
Oh boy.
So far, I'm impressed. Elaine hasn't said what, if any. That's usually her go-to.
I cannot tell you. Probably in 2018, the latter part of 2018 would be my guess.
And how many versions of the script had been written by the beginning of 2021 for Aquaman 2?
Oh, there were probably half dozen drafts of the script.
All right, what, if anything, did Rob Cowan say to you about
What a
chemistry?
city thing.
What
Knew it.
specifically about the chemistry between Amber Heard and Jason Momoa?
Just the fact that they didn't really have a lot of chemistry together. The reality is it's not uncommon on movies for two leads to not have chemistry, and that it's sort of movie magic and editorial, the ability to sort of put performances together, and with the magic of a great score and how you put the pieces together, you can fabricate sort of that chemistry. And so I think in at the end of the day, I think if you watch the movie, they look like they had great chemistry. But I just know that through the course of the post-production that it took a lot of effort to get there. Sometimes you don't. Sometimes it's very easy. You just put the characters on the screen together and they work. And sometimes it's harder. And so,
can you give me anything more specific about what it was with Amber Heard?
This testimony is not helping Amber Heard.
Was difficult for the chemistry?
no, because it's like what makes a movie star a movie star. Like you know it when you see it, and the chemistry wasn't there.
Oof.
Now, you've used the term
Ooh.
fabricated a number of times. What did you do to fabricate the chemistry between Amber Heard and Jason Momoa?
Yikes.
Well, those are just it's editorial.
She can't
a
even
good
fake
editor and a good
likable and
filmmaker
attractive.
can pick the right takes, can pick the right.
Elaine is
moments.
supposed to
So
be
many of the
Amber's
scenes talk about
lawyer.
the lack of chemistry.
Again, score
many.
is a big, the music in a scene makes a big difference. It can make a happy scene feel sadder or a sad scene feel happier. And so it was sort of it's it's just the magic of
It does.
post-production,
It's everywhere.
editing, sound design, music, etc.
And what do you mean by fabricating, though? I mean, were they literally
Good one, Navesh. I
falsifying,
love it.
or were they
No.
just picking the best
No.
music?
Falsifying
Let me finish my
Aquaman,
question.
Elaine?
Were
What
they
the
We're
hell?
picking
literally
the best music and
falsifying.
picking the best looks because that's their job?
Leave
and
it to
that's
Elaine
what
to
they
ask a
do?
stupid question.
That is what we do in post-production. That's what filmmakers do. No, this is on any production. You're doing that. You're putting performances together. Sometimes it's easier than others. This one was more difficult because of the lack of chemistry between the two. But they were able to, James Wan and the editor were able to get it to a place where the end result actually works.
I hate
And it's great.
And in fact, that's the job of every filmmaker, right? Is to put all the
course.
combinations together to make the most successful production.
That's obvious, Elaine. What's your
What
point?
has been marked as exhibit number 5. It's ALH 18247. And this is a text message exchange between James Wan and Amber Heard. And you mentioned James Wan was the director of Aquaman 2, is that correct? And
That's
Aquaman, and Aquaman, the first one, correct?
That's correct.
All right. And James is texting to Amber on August
She is
25,
awesome.
2018. You rated really high with the audience! Exclamation mark! Exclamation mark! You see that?
Yes.
This is August 25, 2018. What's going on August 25, 2018 that would cause the director to send a text message to Amber saying,
That'd be a test screening. So during our post-production of the movie, we test the movie with an audience, and the audience tells us what they liked and what they didn't like. And so that's what he's referring to there.
and they really liked Amber Heard, correct?
Yes, she did. She tested well.
It hit $1 billion, is that correct?
Yeah.
And more specifically, did you play any role in the determination to communicate to Amber's representatives that Warner Brothers was considering not exercising her option?
Yeah, probably in the sense of we had the conversations, and I believe, if I recall, we had that's where Peter Safran offered to reach out to the agent and express which direction we were leaning.
Have you seen any document that says there was any chemistry issues between Amber Heard and Jason Momoa in Aquaman 1?
Documents? No, I mean, those were all conversations.
But if Jason came back and James Wan came back, you were guaranteeing that Amber Heard would play Mira, correct?
That's correct.
You are correct.
And
Absolutely,
Jason
Jeff.
Momoa was able to negotiate a different compensation structure, was he not, for Aquaman 2?
That's true. He did renegotiate.
Now, Aquaman was the highest grossing DC film ever for Warner Brothers, was it not?
Yes, it was.
And what, if any, issues did you have with Amber Heard in Aquaman 2?
My understanding is actually the production went very smoothly.
All right, thank you. Your next witness.
Short and sweet. So basically, it had nothing to do with the lawsuit.
Your Honor, we call.
Had everything to
Dr.
do with
Colbert
movie
next,
magic
but I
being
know we have
required.
a preliminary matter that we need to deal with briefly. If we may approach.
Sure.
Do you think it made $1 billion more due to Jason Momoa or Amber Heard being in it?
Yeah, right.
It was the Laser Sharks.
Definitely laser sharks. So who did they say was the next witness?
Dr.
Dr.
Colbert, he is, I believe, Johnny's actual hand doctor.
Oh, nice. That'll be helpful.
I'll be honest. Elaine saying, so you fabricated? Are you, you're making things up? It's like, actually, Elaine, did you know that Jason Momoa can't breathe underwater?
Is there a historical record for Aquaman
That's
that we should be
hilarious.
shocked that this deviated from?
How or how
We're
about
just
her
being
own
indignant.
client?
Elaine.
Like,
It-
ma'am,
she
are
didn't
you
help her
aware
client
that
at all
your
with
own
that.
client is not actually a fish.
I'm going to watch this. This is going to be great.
Probably
She
not.
may have been lying to you about this. She may have been lying to you about several things. This
It
may
was
be
just
one
the
of them.
indignance. It was like, what do you mean fabricate? It's like, ma'am, we edit things.
Yeah.
But how bad is the chemistry when you have to post-production to try to possibly fake some chemistry between you and Jason Momoa?
Yep.
I'm actually surprised they didn't get the articles in about chemistry right there. You know, it's hearsay, but I'm a little surprised. I thought they'd make
There's
a run
brutal
at it.
film reviews.
And focused on chemistry. There, I was pulling them up yesterday. I can do a dozen more. It's referenced a lot.
And this witness did a great job. He was very believable, to the point, and quick. They made their point, dumped on Amber Heard's assertions, and it was over.
What's funny is, you know, I did laugh when did you talk to Zack Snyder about this? Like, if you follow any of the things that have happened with Warner Brothers and DC, it's like, I think even Hamada goes, no.
And to answer the super chat question, do defense questions during the video count against their time? We're not entirely sure. Our understanding is that time is counted according to who wants that particular bit of testimony in, because oftentimes the questions, the testimony that is favorable to Johnny Depp's side may have come in through a question by Elaine Bredehoff. That's partly because of the way that the nature in which these depositions have come about. So we're not entirely sure about that.
I wonder if that's what they would be fighting about, though.
Could be. Could be. And then CB, can JD's team use deposition to run Amber Heard's time out? Possibly.
Again, I guess it depends how it's calculated.
Yeah.
If so, I would find just the most random, pointless video that you could find where they made the most comments and objections.
Yeah.
It would seem kind of unfair to do that.
Yeah, but that is strategy.
Well, what do I know? Yeah.
I mean, it's strategy. That's also on Amber Heard's side to make sure that they have time for that kind of thing.
Well, they certainly can't argue that they've used their time wisely in view of yesterday and last Thursday's lineup of witnesses.
Okay, you're right. But if I could be advocate for Amber Heard here for just a second, you know, they agreed on the edits for these depositions, like at this point, 2-3 weeks ago. So yes, they ran into the ditch themselves, but they didn't actually know they'd be standing in the ditch at the time. So one of the discussions might be, because it seems to be like, if we're looking at the stopwatch and we think about the differences between the days, that they were counting the half where you talk against the half that you talk, and like the deposition would have a number that it counts for either side on it. That everybody asking, hey, can you run out somebody's clock with depositions? And we say, well, that doesn't seem likely. That might be what they continue to fight about. If they have more deposition testimony, I think that first discussion was definitely a time discussion. Obviously speculation, but that's what I think it was. So looking at this, I don't know what they're trying to sort out here, whether it's experts or depositions or anything else, but it's very interesting because 4 hours in 3 days. It's crazy.
Yep. Agreed. Now, so this is going to be Dr. Kohlberg. Do we know how this is spelled? Can I get somebody? Does anybody have a list of these rebuttal witnesses? I know some people sent stuff yesterday, tagged me in some stuff yesterday. Yeah, I get a lot of stuff, so I don't have it organized here.
It's no worries
because it's not on the he's not on the witness list from what I can see.
I think he is on the witness list. I'm just going to double check.
Is he? Okay.
Yeah, his hand
Kohlberg
surgeon is on the list. It's like Holder, I think it is.
Oh, Holder. Oh, then maybe I misheard.
I was talking with Andrew, Legal Mindsets, about earlier, and someone had a screen capture of the witness list, which I'm trying to find.
Okay, because there's also I know that there's a list from Court TV that was put out yesterday, and somebody had sent me some screenshots of that, which is different from the initial Kulber. Okay, Kulber. Okay,
that sounds like what they said.
Okay, yeah, that does sound about correct. So I am looking here. I don't see him on the initial witness list.
No, he's not on the initial witness list.
Yeah.
I think you're
okay.
right. I think he may have been a deposition. I'm going to check that now.
Okay. Oh, here we go. I got it. Thank you. Somebody did send me Court TV's tweet. Thank you guys. Thank you. Thank you. Okay. What was the cause of Amber Heard's statements? I think maybe because
They can't testify.
yeah,
That would be
she can't.
speculative.
Yeah, that would be highly speculative, and also kind of gets to a legal conclusion. So yeah, that would be why, and you wouldn't want her testifying to that anyway. That's just not strategically great on Johnny's side. Michael Herbert says, "Can JD testify? Had I known, I would have instructed Waldman not to say such things without opening himself or Waldman to CE." I say, uh, 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 no, you don't want to do that at all, because as soon as you start to comment on any of the communications that he had between himself and Waldman, then you start opening up and wearing down that attorney-client privilege, and that is ironclad. So the best answer is to say, I'm not answering that question at all, like regardless of what the justification could be.
I agree, but I will offer another devil's advocate position, which is when Ben Chu stands up there and says, "Can you take it under advisement until we finish our evidence?" It suggests strongly to me that they have a plan to bring Johnny up to discount the Waldman agency thesis, and that one of the strategies they might be doing is trying to run down the time and bring Johnny up last to be the last in front of the jury, and with no/limited cross-examination.
I think the problem with that one particular statement was the "had I known." That opens up the door to "what did you know?"
Yes.
So you'd have to couch the arguments very, very carefully. And I don't know if I would trust Johnny to be concise, brief, and carefully crafted in his answers.
I think it would be more specific than that, but I think it might be the plan. Ben Chu saying, "Can you wait until after we're done with evidence?" I think that's the plan.
All right, ladies and gentlemen, I apologize again. We have a few things to take care of. We're just going to go ahead and take our morning recess now for 15
Morning
minutes. Do
recess.
not discuss the case and do not toss
Okay.
anybody, okay?
All righty.
Do not do any outside research. Sorry, that was the same thing.
She seems to be getting happier as we get closer to the end.
Well, because she has fewer administrative tasks to take care of, fewer like weeds to untangle. That's my guess anyway.
I don't know. Yesterday, she seemed like she was going to kill him.
Is that WebEx? Okay, so I'll get that set up. too.
Everybody felt like
All
someone
right.
was going to
All right,
die.
we'll go
yesterday.
ahead and take a break. Let's make it 10:50 to give them time to look at everything, okay?
All rise. Judge is walking out. Taking a break.
Yeah, and for a judge who likes her schedule, taking the break an hour early. I don't know.
That must be a real issue there. Interesting. Well, I see Larry there, DUI guy. I don't see James. Wonder where he's at. Interesting. Okay. Disordia says, question: could this potentially set a precedent for suing lawyers for speaking publicly about their clients and their claims?
It's not a precedent.
Yeah, it's so setting precedent. When you're asking lawyers about setting precedent, we are going to first and foremost be thinking about binding case law, and how that can impact later case law. This being at the trial court level, it is not going to be making any kind of binding case law. Binding case law would come if there's an appeal and an appellate court makes a decision. But I understand, I think, what you mean by maybe in more of a social context, that people will get the idea that they should be suing lawyers making public statements. I think it might depend on state to state, what's going on there. Now, this is a good opportunity to talk about the litigation privilege too. This is one of the things that has really boggled my mind. There's been a bit of a puzzle here for Adam Waldman's statements, because we have an attorney that is talking about the defense to his client's case in actual active litigation, and Virginia case law. I don't I have looked quite deeply into Virginia case law on this. I'm not exactly sure how it actually measures up to other states because I've never really had to look too deep into it in other states. But basically, like you can't sue a lawyer for making an argument in court. Like you can't sue a
Sure.
lawyer for defending a client in court because it just completely undercuts our entire judicial system. So if somebody makes a claim against someone so you can get back to running around with that little toddler that I'm sure is keeping you otherwise on your toes. For sure. But yeah, this whole issue of crowd control is just so concerning, even just from like looking at it from a lawyer's perspective, like the things that can happen that can come back to bite the courthouse.
It's
You
literally
know, like
amazing that nothing
Yeah.
significant has happened so far.
it
That is
really
such a
is.
such a professional mindset we have, that people see, families having fun at the beach. I'm seeing jet ski accidents, boating accidents, glass on the beach.
I'm
Yeah.
honestly surprised if no fist fights have broken out yet. I would have thought it would have happened already.
I would agree. Oh, okay.
We do have
Here's
some
some
DUI
okay.
guy tweets if
I
you
was
want.
just gonna say, you guys want me to read them?
Yeah.
Oh yeah,
Um, Okay. So starting from 5 minutes ago, UI guy says the AH lawyers arrived this morning and say good morning to each other after they appeared deflated and lacking in energy and fervor. Elaine looked at me and gave me a thumbs up after I mentioned to the deputy that he forgot to say to the panel that we have to stand up for the judge. He was telling us that we do not have to stand up for the jury. I am not sure what to make of it. Oh God, she doesn't know who he is, clearly. Then he says, when JD walks into the room, a girl behind me says, my heart is racing. I respond with, welcome to the Depp effect. And then he says, I cannot believe that the defense rested this morning, but it kind of makes sense because they only have 4 hours left and they have to save it for cross-examination of rebuttal witnesses in to bring their own witnesses. Yeah. So that is 2 minutes ago, and that's it so far. We might see some more tweets from him because it was these are some pretty rapid fire. Oh, here's another one. When Chu made the slap argument, the courtroom audibly shifted. I want to hear how it shifted.
Yeah.
We're gonna continue to I'll keep an eye out on this for when we get another tweet from him. But interesting stuff. So yeah, it sounds like there were some massive line cutters today, and it sucks. I hate to see it. I hate it, just like I hate seeing review bombing, and like I hate seeing like other stuff like that. But anyhow, so how about Walter Hamada's testimony? That was nice and short and sweet, and just basically swiftly undercuts Amber Heard's damages calculation, doesn't it?
Oh,
Any
I
other
so
thoughts
look
on that?
forward to the rebuttal case, how it's just so much tighter and cleaner because it's responsive to what came out in her case rather than just the wide-ranging directs that we've seen. I think there's going to be a lot of bam, 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 quick and dirty, good moments, getting in and out, and that's what I'm looking forward to.
Awesome. Beef Squatch says, question, didn't Catherine testify that Amber Heard continued her L'Oreal contract or get other endorsements after the Adam Waldman statements? She walked in Paris Fashion Week 2021 and maybe other influencer ads on her socials. Andrea, I feel like you know this best.
Yeah, they did. They testified that they did pick up her L'Oreal contract, that they initially extended it for only a short period, but they have subsequently extended it. So she is still a L'Oreal ambassador. She did walk in some show that L'Oreal put on during Paris Fashion Week. She was heckled and booed on the runway. So you can kind of understand why L'Oreal maybe isn't making her front and center as they might have liked. But, that's the consequence of your hiring choices.
I suppose so. Joanne Trinette Dellis Reyes says, give a shout out to my daughter, Samantha Sky, please. She'd be stoked to hear her name. Thanks for making this trial understandable for us. Of course. Yes, Samantha Sky. Hey, how's it going? Thanks for watching. Thematic says, Legal Bites question, if Adam Waldman didn't make statements to the world about Amber, would we even be at this juncture? Would the judge just side with Johnny Depp? It's not up to the judge. It's up to the jury. I think this is an interesting question because I think that Amber's biggest problem, her biggest blunder, her biggest mistake was filing the counterclaims in the first place, because this would have been a much weaker case for Johnny if Amber didn't bring in all of this extra stuff. And if she didn't also have her own burden to prove all of this, what do you guys think about that?
She would have made up a counterclaim no matter what. She would have she would have cited somebody else.
Completely agree.
Yes.
She would have sued for any reason whatsoever.
Wow.
I agree.
Okay.
What
Amber
if
Heard
she
just can't
didn't?
get out of her own way. She had a reasonably strong case against Johnny's defamation claim until she chose to get on the stand and testify. Had she just stayed out of it and held him to his burden of proof, I think she'd be in a much stronger position to be able to argue that this was my reasonable perspective on our relationship. But as soon as she gets on the stand to recount, she just blows any possibility of giving her the benefit of the doubt out of the water. The counterclaim is exactly the same thing. We wouldn't know about her borderline personality disorder and her histrionic personality disorder had she not insisted on going down that road. She is 100% her own worst enemy in this case.
You're absolutely. She's too smart by half.
Mm-hmm.
And she wanted to get in that little dig about Kate Moss, and now look where we are.
The phrase that I like to use is smart enough to be dangerous. And for her own case is mostly in this particular case, I think, at least from what I can see. Pamela 2am says, do you think the jurors will understand inference? They're lay people and not lawyers. It seems complicated to understand. I'm so worried. Thank you. Well, I think that, like, think of the jurors as the way that you're thinking, right?
Mm-hmm.
Like these are people that are I mean, we like to talk a lot about the jury being emotional beings, but they're also logical beings. They are able to look at that and say, I don't understand how you can say that Johnny has directed Adam Waldman to say anything here. I haven't seen any. Like, where are you guys getting this? Like, are we supposed to pull this from thin air? Like they might be thinking that as well. So, you know, the idea of inference and circumstantial evidence, those will all be explained in closing arguments as well. Those are terms that should be explained, and hopefully they will be explained well enough that the jury can take down the definition, go back into the jury room, and say, okay, that's what this is. But I don't see it. I don't see it here.
Plus, I think from a juror's analysis, they're going to go look at just the underlying case and say, I think she was wrong. And it's going to be much more simplistic than that. And just on the merits, we're not going to sit here and think about the agency issue. They're just going to say, I think she's full of it. Yeah, we're ruling against her. Done.
The jury
undercutting all my
instructions
mental
are going to
patterns.
play a huge part in this. The jury instructions. I mean, how detailed are they? How much leeway do they give? What do they say?
Well, I think Mike's right insofar it's literally Johnny Depp versus Amber Heard. Like
Yes.
the fundamental question the jury is going to go in there and answer is Johnny Depp or Amber Heard.
Yes.
And then
Also-
And one of the
figure
things
it out.
I've learned to be very humble about as a lawyer is appreciating that how I think about the case is dramatically different from how the jury thinks about it. Almost 100% of the time, when I've had a chance to talk to the jury after the fact, they have decided the case based on things that I didn't even think of.
Absolutely.
Yeah. And also there was a previous super chat there that was talking about the counterclaim. So apparently that was actually filed by Amber's current legal team. That's so surprising. And I really don't pity them as much on this case because it really means that someone there either didn't do a legal analysis and someone did not brief this issue there, or they did and they did it hastily, or they did and they did it half-assed. And so I don't blame them for the problems that they have right now in this case at all. These are totally avoidable. I don't understand how any single lawyer on her team sees the facts of her case, looks at the arguments, thinks about, this is a lawyer making a claim in representation of his client. I wonder if we're going to be able to get these communications because of attorney-client privilege. You know, like I don't understand. Like who what were they thinking?
The answer is they did what Amber wanted. I mean, I think
Yes.
that just becomes abundantly clear more and more every day. And the timing of the counterclaim is important too. Remember, she first filed in her counterclaim this argument that the great bot conspiracy had been perpetrated by Adam Waldman and Johnny Depp to harass her. and
Yeah.
violate the Virginia Computer Crimes Act. Well, this got thrown out. And
It did.
but before it was even filed, as they were going into the UK trial, when Roberta Kaplan was still the lawyer, there had been publicity about this report that she got from Bot Sentinel, supposedly analyzing the nefarious activity. But even this report only identified 13 suspicious accounts out of like hundreds of thousands of people who have tweeted about Amber Heard. So it's been known to be factually deficient from the very beginning. It's been known to be legally deficient from the very beginning. Amber chose an attorney who was willing to barge forward full speed anyway, in spite of those. That's what she wanted, and it's what she got.
Which is nuts because Rottenborn went to Stanford. I mean, it's like, and I know that the rankings of law schools is not everything, but that is a very difficult school to go to. I'm flabbergasted. I'm flabbergasted that someone, with that kind of a legal education background is going to fall victim to that. It just goes to show that every lawyer can make mistakes, and the U.S. News and World Report rankings for law schools really doesn't necessarily mean all that much. I don't know. We could go either way on that.
I will go the latter way, which is, the credentialism of law schools is whatever. I've had the dumbest ass lawyers from freaking Harvard and Yale, and the smartest
from a tier 3 school. So there you go.
The smartest from places I've never heard.
She's a superstar lawyer.
Exactly. I mean, Camille's from a tier 3 school, and she did a phenomenal job on the cross-examination and gets all the props for that. So this case, if anything, you're right, Rick. If anything, what if anything does this case tell us? It tells us that law school rankings don't matter.
Okay.
Well done.
Thank you. Does defense get rebuttal too if they have time? Now, I thought something yesterday.
Yes,
I don't know
if I was
dreaming this. Does Amber Heard also get some rebuttal time because of her counterclaim? A limited rebuttal time, Andrea?
She gets last closing.
We're waiting for the jury.
She gets a sir rebuttal if she has time to do that, and she will be last in the closing because she gets a sir rebuttal. That's my understanding.
Okay, then I'm corrected in the things that I was saying before, because I thought that was not the case. Alrighty, let's see about one more question here. Miss Ron says, trial not totally about winning for JD, but restoring reputation. Thoughts also backhands by right-handed people cause right side injuries on the face. Yeah, I know there's been a lot of talk about that. And yes,
witness?
I do agree with you in your first question.
Dr. Colbert.
All right, sir, if you could raise your right hand. Do you swear affirm to tell the truth?
Is
under
Johnny
penalty
Depp
of the law?
left-handed or right-handed? I haven't noticed.
I think he's
Your
right-handed.
Honor, I would
He's
just
right-handed.
object that Dr. Culver appears to have a sack of documents right in front of him.
All right, sir, you can put your hand down, and any documents you have, if you could put them away and just
Sack of
testify from your
documents.
memory. Okay, sir?
Sack.
Thank you.
Thank you, Your Honor.
All right, your question?
Good morning, Dr. Colbert. Could you please state your full name for the record?
David Allen Colbert.
And what is your profession?
I'm a plastic and hand surgeon.
And how long have you been a plastic and hand surgeon?
Been in practice for 26 years
Where do you currently work?
at Cedars-Sinai Medical Center
How long have you worked there?
for the past 26 years.
Do you know the plaintiff in this action, Johnny Depp?
I do.
And how do you know Mr. Depp?
I had taken care of him when he had injured his hand.
When did Mr. Depp become your patient?
Sometime in March of 2015.
And what type of treatment did you provide to Mr. Depp?
He had a fracture of his finger with soft tissue loss. And so we reconstructed his finger.
When did you perform the first surgery on Mr. Depp's finger?
I believe it was around March 20th of 2015.
And what was involved in that surgery, just briefly?
debriding the devitalized tissue, putting a hypothermic skin graft, restore some of the soft tissue loss that he had, and then also putting a pin in because he had a displaced distal phalanx fracture.
What was the state of Mr. Depp's hand immediately after that surgery? I'm sorry, I think the audio cut out a little bit. Could you please repeat your answer?
It was injured and he had soft tissue loss and a fracture of his distal phalanx.
And what type of cast was on Mr. Depp's hand after you performed that surgery?
It was a plaster splint.
And can you please describe to the jury what a plaster splint would look like?
So it's like a cast, but you don't want to put everything circumferential on it because of swelling after surgery. So I believe in Mr. Depp's case, it was like 2 fingers. I think the 3rd finger was the one that was operated on. So these 2 fingers, the 3rd and 4th finger together, and it's a splint with plaster on the top and on the bottom that goes around the hand to protect it.
How mobile was Mr. Depp's hand when it was in that cast?
Well, he couldn't move his 3rd and 4th fingers because of the bulkiness of the splint. Typically, post-operatively, it's a more bulkier splint right after the surgery. So it's not very, it gets in the way.
Could Mr. Depp grab someone with that cast on his hand?
He could attempt to grab someone. I don't know how successful he would be. He had his index finger free and his thumb free, but the other fingers were probably not being able to move.
How long was the pin in Mr. Depp's finger?
About 11 or 12 days.
And how was the pin removed?
It was removed under local anesthesia in my office.
How long did you ultimately treat Mr. Depp for his hand injury?
For several months.
And why was that?
It was a bad injury. It required a few more little office procedures to clean up the tissue. He had an infection as a result of the injury, so he had to be on antibiotics for some time until it finally completely healed.
Do you recall when the infection developed?
It was a few weeks after the surgery, and that's when I took out the pin.
When was the last time that you saw Mr. Depp?
Sometime in 2015. I don't recall when.
And when was the last time that you spoke to Mr. Depp?
The same, around 2015.
Thank you, Dr. Colbert.
All right, cross-examination.
Whoa,
Wow, that was
that's quick. That was sweet. I'm so used to these taking days.
Good morning, Dr. Culber. So you said that this plaster splint was put on after surgery on March 20th, 2015?
Yes.
And a plaster
Yeah.
a plaster splint, is that sometimes called half a cast?
Sometimes it's called half a cast or a soft cast, something like that. Yeah.
And it's made of plaster of Paris, right?
Correct.
And plaster of Paris hardens like a cast does, correct?
Yeah.
It is a cast.
So other than the fact that it's a little smaller than a cast that goes around your whole hand, it's just as hard as a cast that would be put on a broken arm or a broken hand, correct?
Well, it's softer on the side so the fingers can expand for swelling. So it's not fully, the plaster appears circumferential around everything. So there are areas that are softer to allow for swelling.
But the parts that are covered with plaster of Paris are just as hard as any other cast, correct?
Correct.
And regardless of whether Mr. Depp could have grabbed someone with the hand with the cast on, he could have grabbed someone with the hand without the cast on, correct?
What?
Correct.
Michelle, can you pull up Exhibit 400, please? This has been admitted, Your Honor.
Katie doesn't like this line of questioning. She's not a fan of Rottenborn.
Permission to publish?
Yes, yes, sir.
Kevin.
Dr. Culber, I'm just going to ask Michelle here to just scroll through these pictures, and I'd ask you to take a look at them.
Your Honor, I'm going to object for lack of foundation for these photographs.
They're already in evidence.
With respect to the questions.
Michelle, if you could go back up to that, stop right there. Is there anything about the cast that was put on Mr. Depp's hand on March 20th, 2015 that would have prevented him from doing this damage to Miss Heard's closet on March 23rd, 2015?
Objection calls for speculation.
Yeah, a little bit.
I mean, he had his other hand available. So.
No further questions. Thank you.
All right, redirect.
All right. Also short and sweet.
Dr. Culber, how many fingers were in the plaster portion of Mr. Depp's cast?
I believe 2 or 3, at least 2 were, and the third one and the fourth one.
And why did you call it a soft cast?
Because it's not fully, plaster doesn't go around the entire hand because you allow for swelling. So there's plaster to protect the fracture. So there's a little plaster on it, but it's on the top and the bottom, but it's not completely circumferential. So there's soft spots to it.
And where are those soft spots located again?
Usually we put a piece of plaster underneath the fingers and on top, and then the sides of the fingers, it's soft so that the fingers can swell after the surgery.
Could Mr. Depp have hit someone with the hand that had the cast on it?
Dangerous question.
He could have hit someone with it. It probably would have injured, damaged the cast.
Okay.
Did you ever notice any damage to Mr. Depp's cast when you treated him after the surgery?
I don't recall. But nothing that comes to mind.
Could Mr. Depp form a fist with the cast on?
No.
No further questions. Thank you, Dr. Kohler.
All right, thank you, sir. That concludes your testimony. Thank you.
Well, that was zippy.
All right, your next
that-
witness.
The highlight for me
So
was a
refreshing.
foundation objection on photos and evidence. I don't know. I like that.
Plaintiff calls Richard Marks, Your Honor.
Wow, I would like to have heard some testimony about the
What a
angle
stupid
below
thing to do for Amber's team to talk about a closet he destroyed. Like the doctor said, he still
I
had
don't
his
think you
other
need to, though.
hand. I mean,
He-
what
he-
was the point of
He was
that?
properly
Skips a
taken
second
down,
and
I
see-
think,
yeah, sir,
yesterday.
you
So
are-
because
if I
he
can
threw
just
his stuff in a
off.
closet,
Okay, sir.
that makes him a wife beater? Get out of here.
So which witness is this now? Did they say?
It's Richard Marks being recalled, the
Oh.
entertainment expert.
Okay. Why did I not recognize him?
He just hasn't said he's invented Star Wars. He worked on Jaws and he did the robot.
Back to the guy who actually knows movies.
Yes.
There is a
Oh my
difference there,
God.
isn't there?
There is a massive difference. He knows because he made them all.
Sir? Yes, ma'am. Thank you, Your Honor.
or at least he.
Welcome
you know,
back, Mr. Marks.
He argued the deals.
You've testified in this case previously, but would you just briefly remind the jury who you are?
I'm Richard Marks, and I'm a full-time entertainment transactional attorney. I make deals every day for productions and for individuals. I'm in the trenches negotiating and then making sure the contracts reflect the deals. And I'm very much distinguished from the other side's expert, who is not an attorney, who's not in the trenches making deals, is not in that day-to-day process.
And are you familiar with the testimony of Catherine Arnold in this matter?
Yes.
Have you been asked to analyze that testimony and provide opinions in response?
Yes.
And generally, what are those opinions?
Well, my opinions are that she's very slick and smooth, but she's not an expert in deal making. Her assessment of damages is built on nothing, and it's wildly speculative.
Are you familiar with Ms. Arnold's opinion that it's customary for an actor to renegotiate the fee for a subsequent picture option in a multi-picture contract when a film is successful?
Yes, I heard that opinion.
And are you also familiar with her testimony that under those circumstances, an actor will renegotiate a 50 to 100% increase in their salary for the next optional film?
Yes, I heard her say that.
Do you agree with those opinions?
Absolutely not.
Why not, sir?
Well, what we're dealing with in this case is a test option agreement. And that's an agreement. It's a multi-picture agreement. And it's the nightmare for people like me. The test is going to take place, let's say, for 10 actors the next morning at 9. And you have to fully negotiate a contract that might cover 4 movies and have it signed before they're allowed to test, so that if they're chosen for the part, we have the full contract. There's no renegotiation. So you've got a contract for a multi-picture deal. It's usually a franchise, and you negotiate the first movie. And normally, if they get the part, they're the chosen one. They're the stars born moment, if you will.
For those of you who weren't with me the first time, this guy is
Normally,
awesome.
their salary is inflated from their normal salary, because now they're going to play a character that could go on for 4 movies. In this case, Ms. Heard's first salary,
Get your point, Jeff.
she got the part, was $450,000. If Warner Brothers and DC Comics decided to make a next movie, they could recast her. They had no obligation, it was an option. But if they did cast her up front, that they had agreed to more than double her salary, like 2.25 times to get to the $1 million. These are large bumps, if you will. If an actor is on a series, say, they go and they have 5 options. They go up in increments of 5%, 10%, 20%, not these multiples that you see in a test option agreement. And that's one of the reasons that they aren't renegotiated.
He's so good.
normally.
He was a great witness
They
the
are in
first
some
time.
instances, but not normally.
What's the significance of the test part in a test option agreement?
The test significance is that an established actor usually wouldn't test. They'd be offered the role. Ms. Heard was in a group of actors that needed to be tested to see if the studio wanted to hire them. And then if they hired them, they would be locked up for potentially 4 movies at very lucrative increases, because after Aquaman 1, she gets to $1 million. Aquaman 2, she gets to $2 million. And Aquaman 3, excuse me, you get to $4 million. These are unheard of bumps if you're going on a normal career. and trying to increase your salary by increments.
In your
West Texas
experience,
Zombie
what
Slayer,
is
thank you for the
customary
generous
for
super chat.
negotiations of
Also,
multi-picture deals?
Congratulations, I guess. Hope you feel
Well,
better.
I think what happened in this case was customary for negotiation of multi-picture deals. And by that, I mean that you assume success. The reason you go from the first Justice League movie where Miss Heard played Mira the first time, the reason you more than double her salary is you assume success. So you've already built in the bonus that Miss Arnold was referring to, a renegotiation, if you will, for the third movie. Instead of doubling her salary, Miss Arnold said it would only be fair to quadruple her salary. And that's just not the way these idiosyncratic contracts work. They're a very small portion of the contracts we deal with.
Are you familiar with Ms. Arnold's opinion that Ms. Heard's salary for Aquaman 2 could have been renegotiated to around $4 million?
I am.
Do you agree with that opinion?
No.
Why not?
Well, as I've said, that would now be after a healthy first payday. It's more than doubled, and now it would be quadrupled. That's not the way it happens. Walter Hamada, who is the president of that part of the studio, said it doesn't happen. They're not going to do it. Miss Arnold, for some substance, says, well, Jason Momoa got to do it, but she doesn't give us any of the details. We know that Jason Momoa was in a movie before the Justice League. He played Aquaman in a movie not with Miss Mira in that movie. So he had a history before the first movie with Amber Heard. He played Aquaman.
A history
We
that she
don't
didn't know about.
what his contract state of it was when you got to Aquaman 2.
Mhm.
And she says, unsupported, that he renegotiated. We're not sure what he renegotiated to. But I can say that at the end of the option period,
I have
when
something I
only
want
one
to say about
option
this
left,
comment, Jeff, though,
and you
but I want to
want
hear
that
him
star
first.
in more movies, you may renegotiate, but it's not a gratuity. It's, we'll give you more for the last option if you'll give us 3 more options. It's a give and take.
Mhm.
And unfortunately, Miss Arnold didn't give us any of that background or those building blocks. And then I think yesterday she said, and the other actors renegotiated. And again, we don't know their salary history. We don't know their contracts. We don't know anything except she's asking you just to believe her as what I refer to as a professional expert.
Are you aware that Ms. Arnold's opined that but for the alleged defamatory statements by Mr. Waldman, Ms. Heard would have earned $45 million in the last 18 months and then the next 3 to 5 years?
Yes, I am.
I'd like to address some of the components of that one by one with you, Mr. Marks. Are
That
you
was a
familiar
dead-on
with the
explanation
testimony
of
that
options,
Ms.
by the
Heard
way.
would continue to make films for approximately $4 million each following Aquaman 2?
Yes.
Do you agree with that testimony?
No.
Why not?
Well, again, in Aquaman 2, Amber Heard has already had this huge increase. She worked on Aquaman 2 for $2 million. What Ms. Arnold is saying is, oh, she should have worked on it for $4 million, which I disagree with. And I think there is reasons to negotiate that weren't here in this case. So the $4 million I have a disagreement with. But even if it was at $4 million, or if it was at $2 million, the 4 or 5 movies that Ms. Heard might get might be independent movies. They might be standalone studio movies. They might be passion projects. Every actor has a quiver full of quotes, and their highest quote is for the superhero fantasy journey. Their lowest quote might be for the Independent Passion Project, where they'll defer their salary and almost take nothing to work, just SAG minimum. And to assume that she'd get 4 or 5 more movies at this, her last fantasy quote, would be to assume that those are also those type of movies, playing another character. And Miss Arnold says that Miss Heard's breakout moment, her Star is Born moment, is Christmas.
Let me know. Can you guys hear? Okay, I want to make sure the audio's good.
True. Those moments,
you can hear it. Just let me know, yay or nay.
But if it's true, as a deal maker, you would expect, if you represented producers, production companies, to flock in to take advantage of this hot star and to sign them up. And we have from Christmas 2018 to spring 20, where there is none of this activity. The Star is Born phenomena didn't happen. Miss Heard starred in one series of 8 episodes, and she earned a healthy fee, $200,000 an episode. But that's 5 times less than the million Miss Arnold is tossing out, supposedly based on Jason Momoa's quote. She doesn't prove it or give us facts. And Jason Momoa is not a comparable actor. He's been in a series where they shot 78 episodes, 44 episodes, 21 episodes. He played Conan the Barbarian. He was in Game of Thrones. It's not a comparable.
Unresponsive to. All right, I'll sustain the objection. Next question. Mr. Marks, we'll get to some of those issues in a moment, but I want to take you back for a second. I believe you testified a few minutes ago that your understanding is that the last option in a multi-picture deal might be renegotiated under some circumstances. Do you have an understanding of whether Aquaman 2 was the last option in Ms. Heard's contract with Warner Brothers?
Oh, no. Aquaman 2 has not even been released, and Warner Brothers has a 4th option for Aquaman 3 or another movies where Mira appears, that character, and they've agreed to double the salary again. So it's in success, and that assumes that they recast and that they make the movie.
Are you aware of Ms. Arnold's testimony that Ms. Heard would have made several $1 million on endorsement deals, such as the one she had with L'Oreal?
I'm aware of that testimony.
Do you agree with that opinion?
No. Again, this is a
That's a great comment.
Personalities. We didn't, after the breakout moment that Miss Arnold talked about, Christmas 2018, we didn't see endorsement deals flocking to Miss Heard during that 16-month period before Adam Waldman made a few statements in the London Daily Mail, I believe it was. We didn't see those endorsements coming to her. We didn't. What Miss Arnold shows you is these non-comparable actors. They had endorsement deals, but she doesn't show you when she describes the breakout moment and why she's comparing Amber Heard to these, what I call uncomparable actors, but she's making the comparison. She's saying, well, they had all these.
In other words, she doesn't compare to them. But real quick, Jeff,
but for
if your woman had cut off the tip of your finger, you might destroy her closet too.
Primary question is what happened in the 16 months. Even if you believe 3 statements in the Daily Mail are the stake through the heart of this Stars Born moment.
Do you have an opinion about Ms. Arnold's testimony that Ms. Heard would have made $1 million an episode in a couple of streaming series following her A Star is Born moment?
Yes, I heard it. I have an opinion.
What's your opinion?
Well, after Aquaman 1, this is a major coup. Amber Heard got that role. She tested for it. She could have been the other 19 actresses or 10 or whoever else tested, didn't get it. She got the role, and she got her salary doubled for Aquaman 1 to $1 million. Now, Ms. Arnold wants you to believe that that $1 million would translate into, she'd get that for each episode of a series. We know what she got for a series. She got a series in that period after Christmas 2018, before spring of 2020. She got a series. It was 8 episodes, and it was $200,000 an episode. And Miss Arnold is from somewhere in a glib way saying she got a couple series and $1 million each. And I can tell you, as someone in the trenches, rarely does an actor get $1 million for a series episode. And again, in those 16 months, there were no offers for series at $1 million an episode. In fact, her only series is the 200,000. And if you look at her resume, the series that Miss Heard were in, I think the longest one ran 8 episodes. Jason Momoa, if you were to believe Miss Arnold, and somehow Jason Momoa's agent broke their confidentiality in the agreement, and he had a series at $1 million an episode. If you're to believe that, Jason Momoa has had a series with 78 episodes, with 44 episodes, with 21 episodes, with 18 episodes, with 21 episodes. He was in, again, there's not a comparableness there.
We spoke a few minutes ago about the test option agreement.
You would know.
What's the significance of the option part of that agreement?
The option part of the agreement gives the employer, the studio, the option. They don't have to do anything. They have an option to either employ you at a very healthy salary to play this role or not. They can recast the superhero role. You just have to think of how many actors have played Batman or Superman. They can do what they want. And indeed, since there's no contract, they only have a choice to exercise their option or not. They might say, we're not exercising unless you reduce your compensation. Who knows what the negotiation would be? But it's not a contract until the studio exercises the option, and they don't have to.
What's the alternative to an option agreement?
Well, the alternative is most agreements in Hollywood, you're hired to play the role. Or once you exercise the option, then it becomes, for that picture, an agreement like others in Hollywood. You are now hired to play that role. So
right.
Most contracts are guaranteed. You're hired to play the role. In an option agreement, once they exercise the option for that movie, it becomes a guaranteed contract.
That's what exercise means.
Are you aware that Ms. Arnold testified that Ms. Heard was released from her Aquaman 2 contract and then subsequently rehired?
Jeff, you're right. This
I heard
witness is very comfortable in
Is
the
that
stand.
consistent with your
He
experience
was
in the film
fantastic
industry
the
in
first
connection
time too.
with these multi-option contracts?
No.
Why not?
Again, studios
He knows his
don't
stuff
do
though.
things
He
they don't
practices
have
this
to do.
every day.
As we heard Mr. Hamada, the president of the studio, say, you either exercise your option or you don't. They exercise their option. He denied releasing and then rehiring.
For anyone out there as well, watching,
My
listening,
experience,
Facebook, YouTube,
5
Twitter,
decades in the business,
that's the
doing
link
this
to
type
join
of
me if
work,
you'd like to.
not talking about it, not consulting. I mean, I have, you know, I heard Ms. Arnold say she'd been an expert 100 times. I'm a transactional lawyer. I do this occasionally. Basically, you know, it's not a contract till they option it, and they pick up their option, and at that point, it's guaranteed contract. and then different rules apply to it.
In your experience in the industry, do studios typically comment on those types of actions that they're taking with respect to options?
No, just like Mr. Hamada said, they don't need to comment on it. They either exercise the option or they don't. In Hollywood, silence is the default. You play no card before it's time. And the cards there were exercise the option or not. And I was surprised by Mr. Hamada under oath, basically saying that there was this discussion of chemistry. That
Objection, Your Honor, hearsay.
I think it was an in-court statement this morning, I believe, Your Honor. That's fine.
It's the same hearsay that you were.
It's an
hearsay like
evidence.
yesterday.
It's an in-court statement.
Yeah.
It's not hearsay.
Laney listed it.
Yeah.
Johnny didn't object.
Wow.
Go ahead.
Wow, 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 wow.
Overruled. You can continue, Mr.
Oh.
That does not meet
I
the
was
definition of
surprised
hearsay.
they talked about chemistry. That would normally be behind closed doors because it can't help your relationship with the actor. You're either going to exercise or not. And that was quite a bit of candor from someone at his level.
Wow.
And so, therefore,
that means
at face value, I
Amber
think he
could have
felt that he was
issues.
under oath and he was telling the truth, but it wouldn't
Objection,
be.
Your Honor, is
I'll sustain the objection.
Good
Mr.
job,
Marks, are there
Mr. Marks.
circumstances
Slid
where a
that one in.
studio would be more likely to say something about not using an actor again in a franchise?
Yes.
What are those circumstances?
Once they've exercised the option, once the contract is guaranteed, the studio still has the right to pay the actor, but not pay or play them.
Right.
And that is a rare condition because you've hired the actor, you've got to pay them, but you say, go home, we're recasting. In that situation, after you've exercised the option and the contract is guaranteed, if you pay off the actor, that's normally commented on. That becomes a bit of information because it's not.
The woman sitting next to Amber's name is Elaine, and
Is
she
that circumstance different
not
from
very good.
Ms. Heard's contract with Warner Brothers for the Aquaman movies?
Oh, yeah. Ms. Heard's contract, again, it was just an option. Either we exercise it or we don't. And if we exercise it, she's in the film. If we don't, she's not. Until we exercise it, we have our right to recast or not make the movie. And even after we exercise it, we still have a right to recast and not make the movie.
Correct.
We just have to pay her salary.
Do you understand that Ms. Arnold compares Ms. Heard's career trajectory with that of other actors, including Jason Momoa, Gal Gadot, Zendaya, Ana de Armas, and Chris Pine?
That was ridiculous.
I heard that.
And what's your opinion of those actors as comparables for Ms. Heard?
Even Ms. Heard's agent, Jessica Kay, said that 4 of those actors weren't
objection, Your Honor,
comparable.
hearsay.
It was
It was
I
in
believe
court.
Same response, Your Honor, that it was in testimony that was played
Yeah.
earlier this week.
I mean, that's not what you testified to. I mean,
Then that's mischaracterizing the evidence. That's not hearsay.
Yeah.
But you can cross-examine.
Yeah, exactly.
Nice.
So again,
Lady Elaine Fairchild gave the look.
Jason Momoa was Aquaman. Chris Pine was Captain.
Yeah, that was quite a look from Elaine.
Gal Gadot was Wonder Woman. Zendaya has been working on Disney Channel since she was 13. She's in all the Spider-Man
We've
movies.
learned.
She goes by one name. Ana de Armas.
She goes by one name is great evidence.
Yes.
A movie that they call.
He's not wrong,
that's
but it's just
her
a funny
breakout.
point to make.
That's how
It
much
was
better
as
she
a
is.
nude
She needs
poster.
one
She's
name.
been an ensemble piece, Knives Out. These are not comparables. Now,
That's right.
Miss Arnold stuck to Jason Momoa, who's the most non-comparable because of his history and his career. But she didn't give us the advantage of telling us what his contracts were, what he renegotiated to, what he earned. She didn't give us any of those
he is
building blocks. She just
destroying
created,
Amber's witness
she
from
set him
yesterday.
up as a comparable and then said what Ms. Heard should earn, but she never gave us the salary of Jason Momoa or the other comparables. And
she gave us 15 million
she
profit
built
main too.
like this house of cards on nothing. She showed us
Sit on a throne of lies
with her words the beautiful clothing that the emperor was wearing, but we can see, if you know the business,
Emperor has no clothes.
Objection, Your Honor.
that he wasn't.
Beyond the scope of the question.
All right.
Objection, Your Honor. He's using a metaphor, and I don't like it.
You were just speaking about Mr. Momoa as a comparable. Are you aware that Ms. Arnold compares Ms. Heard to Mr. Momoa as an
he's
actor with
objecting to the form of the answer.
experience, who was able
yeah.
to renegotiate his
one.
salary for significant increases in bonus?
Yes.
What's your response to that opinion?
Again, he didn't have comparable franchise experience to Ms. Heard. He was Conan the Barbarian. He played Aquaman in a movie that Amber Heard was not in. He played Aquaman, not a supporting character like Mira. It's just not comparable. And
He is
you can
destroying
see the
their
words,
argument about
but
Amber's
I saw nothing from Ms.
earnings
Arnold
potential.
to back it up. Something to build on, which if she was a negotiator in the trench, the studio negotiator would say, okay, so show us, where's the comps?
Yep.
Let's talk numbers, because ultimately that's where we have to
That's
get
what
to.
matters.
Not just because you say it's so. We just don't believe you. You've got to show us.
In your experience in the industry, what factors influence the negotiation of the terms of a film agreement with an actor?
Madonna, Lady Gaga,
Well,
Cher, Prince. Nice.
I mean, first, it depends on the film. If the film is $1 million movie and everybody's deferring their salaries, that's one thing. If it's a superhero movie, that's another. But for deal makers and negotiators, the best predictor of what the deal should be is past earnings, precedent, comps. You also look at the budget of the movie, what it can bear, because if Jason Momoa's comp is $10 million, but the budget's $10 million, obviously he has another price for that movie. But the best predictor of future earnings is past earnings. And I didn't see any Ms. Arnold talk about past earnings at all, except the earnings in this rarefied superhero 4-picture deal, where instead of incremental increases, which you normally see, it was multiples increases. And then when you get on a series, the big renegotiation was when the network has no more options. Until then, the actors on the series get 5, 10, 15 small percentage raises. They don't get multiples. They get the multiples if it's success and the studio wants to continue making the series and they want to keep these characters. That's when the renegotiation happens. Here, even if we believe Ms. Arnold, after Aquaman 2, there was still an option waiting at a big price, double the previous payday.
What's the significance of the timing of the Waldman statements to the opportunities Ms. Arnold claims Ms. Heard lost?
Well, the argument, as I understand it, is that Ms. Arnold says that Ms. Heard lost all these opportunities because of those losses were caused by Adam Waldman's statements 16 months later. So I think the timing.
Sure.
Don Wrinkles over here is pretty great.
I will tell you that from a transactional perspective, everything is dead on.
Nice.
I don't know what
Wrinkles blast.
I don't know if Hollywood does some weird stuff on the edges that maybe Amber Heard's team is right about. But as for why they enter into these contracts, how they would think about them once they're in their hands, where the leverage would be, everything. That's my 17 years of negotiating contracts. He's dead on.
And this guy really comes across as a Hollywood guy.
He does, doesn't he?
Yeah, I
He's
mean,
completely
guys,
And
part
he
of the
knows
cast.
who Batman is.
I don't
That's
know
an
if you
improvement.
guys are aware. I don't know if you guys are aware, but this actually is Jack Nicholson. He spent so much time in Hollywood that he started negotiating deals.
There you go.
Mr. Marks, what's your overall assessment of Ms. Arnold's opinions in this case?
She's
I think it's no good.
My overall assessment of her opinions is that they're not worth the paper they're not written on. She knows something about business, but not about negotiating deals.
Shots
She
fired.
may
out
have
there
gotten someone at the
Oh.
Denver office to breach confidentiality.
They're not worth the paper
But
they're not printed on.
she never laid out the building blocks.
Excuse me, objection. You have to stop talking, Mr. Marks. Thank you. Beyond the scope. Yeah, Ms. Marks, can you just limit your testimony to your opinion about
Okay.
Ms. Arnold's opinions, please?
My opinion, as someone who's made deals as a deal maker for almost 50 years, is that she calls herself an expert, but she's not. She doesn't have the background. She doesn't have the day-to-day knowledge. And her testimony that I heard did not back up her bottom line. If you want to get those figures, you have to show why they're deserved.
Yeah.
And again, she was constructing a Jenga without the bottom pieces. It does not hold up under scrutiny by someone who makes deals.
No further questions. All right, cross.
Damn.
Okay.
Let's see.
Wow.
Wow. Let's good luck on the cross, man.
Good.
He's Isaac
luck.
Baruch. He's just authentic.
Yeah.
You just buy it.
When you
Yeah.
put an expert
Behind
up like
Isaac,
that,
Well, because
My
he
number
gives,
two
he
guy.
gives
Morning,
his
Mr. Marks.
reasoning for it. I
Good
mean,
morning.
oh, it's Baby Rottenborn.
So you agree
Yeah.
that studios use
can I
comps to
object my own
negotiate
statement again, please?
deals, correct, with actors?
Sometimes they do.
And
Oh, that was
you
a
have an issue
takedown.
with the
That was a
comps
takedown.
that Ms. Arnold used, correct? As you testified to.
I have an issue with the comps that she says she used that she didn't disclose.
The comps being the actors that you just talked about. She did disclose, she disclosed the actors.
She disclosed the actors and budget figures from their movies. She never disclosed their salaries and salary
She did
history.
15 million for
as
Aquaman. He's wrong on
comps.
this.
You're not offering a different set of comparators that should be used, correct?
I'm saying if you are going to,
That's not my question. Are you offering a different set of comparators than what Ms. Arnold?
Like it's his burden to prove her damages?
I'm not here offering comparators. I'm saying what she offered
You're not
are
offering
not
comparators.
comparators.
That was my question. You're not offering comparators, correct?
No, I would say that Ms.
That was
Spears'
my-
yes.
comparisons
Sir,
are where
respectfully,
you
that
look.
was my question.
All right.
Oh,
Strike
grow
after that.
up.
Just answer
You,
the
mo-
question.
you motion
The
to
jury
strike
can
that?
handle it.
Hey, you're a deal maker, correct?
He wants to win a motion.
Yes.
What actors have you negotiated for in superhero movies?
Well, recently I've negotiated for Chris Pratt in a superhero series for Amazon. I've negotiated a deal for Michael Douglas, not in a superhero movie, but a historical movie. I've negotiated recently
Probably
a
none.
deal for Paul
Yeah.
Rudd and Will Ferrell on an Apple series.
Oh yeah, that one.
Billy Crudup on an Apple series. Those are the recent talent deals.
What actors have you negotiated for in superhero movies?
As I sit here now, I can't remember a superhero movie
But why does that matter?
that I've
It's
budget that
negotiated.
matters.
As I
I've
sit here
certainly
now, it's pretty
negotiated
much
over
an
my
announcement that
career
I'm about to bullshit you. So,
franchise
press
movies
your witnesses, folks.
and fantasy movies.
Yeah.
Your Honor, so it's no, you haven't negotiated with for any actors for superhero movies, correct?
So you would define like, I don't know, Jungle Book isn't a superhero movie. It's more of a fantasy.
So no, correct. Your answer
Okay,
is no.
all right. So as I sit here, I can't think of a
But when I
Marvel
stand,
type superhero movie.
when I
that
stand
I've,
in on the subway
negotiated.
platform,
Although I know
I
there's
have these
one or
incredible.
two in there.
Now, you testified and you agree that Mr. Momoa negotiated his multi-picture contract for Aquaman 2, correct?
I heard Mr. Hamada say there was a renegotiation, but no facts were pro-offered, such as he didn't have an option. His options were out, what he was earning and what he renegotiated to, and he is Aquaman man. So yes, I did hear there was a renegotiation.
And you understand that his salary went from $3 to $4 million to $15 million.
If you tell me that, I haven't seen his contract and I haven't heard any testimony under
She
oath.
said that, Marks.
That's where the leap was.
Now, Ms. Heard's contract.
Did he get more? Did they get more options for when they made that leap? Did they get more options?
Ms. Heard's contract was a talent option contract, correct?
Yes.
And you agree that for if there's an Aquaman 3, Ms. Heard would have an option to receive $4 million, correct?
Jeff, the C stand
Well,
for see you next Tuesday.
Language at Warner Brothers would have the option to engage her.
And if they engaged her, she would receive $4 million, correct?
Yeah. She doesn't have the option to refuse. They have the option to engage her.
And she would receive $4 million, correct?
Yes, $4 million.
Would you agree that the money Amber was making on Aquaman 2 or 3 would be her market rate for future studio movies?
What?
I would think it would be her rate for future studio superhero movies, but not necessarily studio movies that aren't superheroes. That could be standalone. That could
I got
be
you,
other type of
Jeff.
studio
I got
movies.
you.
But for studio superhero movies, it would be $4 million, correct?
If I was Ms. Heard's agent, that's where I would start. Assuming everything was equal, the budget of the superhero movie, that she was in the ensemble. There's a lot of ifs to look at, but all things being equal.
You agree that Aquaman was a breakthrough role for Ms. Heard, wasn't it?
It's the first movie of that ilk that she makes, but she is not Aquaman. She is Mira.
But it was a breakthrough movie for Ms. Heard, correct?
For her, it's a breakthrough movie to be in that film and in the ensemble. Absolutely.
And she was the female star of that movie, correct?
I believe so.
You would agree that for all of the actors Ms. Arnold listed as comparables, their career trajectory went up after their breakthrough, correct?
Yeah.
She didn't give us the raw materials to look at, but I'll take your word that all those unrelated actors in unrelated films, except for Jason Momoa, they went up. As did Miss Arnold's when she went from 1 to 2.
In your experience, can you identify an actor or an actress who's not been able to get a new studio movie after a breakthrough performance in a superhero movie?
As I sit here now, I haven't been
Terrence
asked
Howard?
to opine
Yeah.
on that.
Mr.
There are
Cheadle?
lots of
Terrence
supporting
Howard would
characters
be one.
in
Don
the
Don
Cheadle
Cheadle
also
took it
has done
over.
Yeah.
Terrence
They're
Howard
the
is the
next
answer to
movie.
that question, sir.
Yeah.
But a female star in a breakthrough movie in a superhero movie, can you identify any actress who's not
Evangeline
gotten
Lilly.
another studio movie after that?
Evangeline Lilly.
Well, she's in studio movies.
Well,
She's cheating.
after Miss
Yeah, but she doesn't have
Heard's
her
breakthrough
own-
in 2018.
her
she
own
did
movie,
get
though, you know what I
Aquaman
mean?
2.
Aquaman 2 was already, she already had the option for Aquaman 2,
All right,
correct?
so she did. Miss Heard did not get any movies after 2018, long before the Adam Waldman statements.
Other than Miss Heard, can you identify any actor or actress who's not gotten another studio movie after their breakthrough in a superhero movie?
Another.
As I sit
studio
here
movie.
now, I haven't been asked to research that, and I can't. That would
Okay.
be
Katie
a normal
Holmes?
thing.
And you're not providing an alternative number for Miss Heard's damages, correct? For the jury.
Correct. I'm not providing an alternate number. I think she's been more than adequately paid.
Yeah,
bad question.
That's all. I mean, my question was, you're not providing another number.
I think it's in fairness and the full answer to the question, Your Honor.
It was a yes or no question. He said his answer was no.
I'm not going to strike it.
Okay.
Nice. Go strike it.
No further
All
questions.
right. Redirect.
Ah, sister of Jill.
Yeah, that was a.
Mr. Marks, in response to some questions from Mr. Nadehaft, you were
Don't even do a redirect.
discussing some franchise and fantasy movie agreements that you've negotiated with actors. Could you just describe some of those for us?
I think this is okay, right? Like, talk to us about how awesome
You
you
know,
are. and then we'll
I've
drop
had
it.
such a long career that I mainly forget what I've done, but I negotiated
I'm so
all
experienced. I forget my
the
experience.
contracts for.
I feel this
Pinocchio
man.
I love it.
that was produced.
I couldn't tell you everything I've done.
Yeah.
I'm happy to
You know,
remember
is
my
Coming
open
to
cases.
America the original?
Yeah.
Is that a fantasy movie? The Golden Child, is that a fantasy
Yeah.
movie?
Those are good movies.
Wow, nice Golden Child blast there.
Yeah, and by the way,
He means
I
the
may
silent
have
version.
negotiated contracts, and ultimately the film wasn't made. But as I sit here now, those are the only ones that come to pass. Folks looking at my resume or going through my files, I might think of others, but there isn't a deal that I haven't made.
And I think you also testified in response to Mr. Nadelhaft's questions
Star
that
Wars.
you have negotiated.
Daisy Ridley was
some
in a
deals for,
Orient Express
Chris
with
Pratt
Johnny Depp.
and Paul
so-
Rudd.
She
Do you recall
was.
that testimony?
Yes, these are for a streaming series.
I think she's
Do
also
you happen to
supposed
know
to be
if
in
both of
Knives
those
Out
actors
too.
have played Marvel superheroes?
I believe they have, but don't quote me because that's not my genre.
No further questions, Your Honor. All right. Thank you, Mr. Marks.
To answer your question, Jeff, the petition to kick Amber Heard out of
Thank you, Sally.
Aquaman
I'll
2
invite you.
is over
All
4
right, folks, I have
million
to
now.
practice some law
Not
for a
3
little
million.
bit. I
4
will be
million.
back.
What?
Wow.
I
does
will
that?
be back.
All right, Rick. Thanks so much.
Keep track
for
of
hanging
everything
out
while
with
I'm
us.
gone. I want to hear a full
Of course.
In fact, I'll look
Of
it up
course.
real quick. I think it's
Testified previously.
4.5
Congrats, Mr. Spindler.
million.
All right.
Let me
Just
check
a
it
reminder
out.
that you're still under oath. Okay, sir? All right. Thank you.
Mr. Spindler.
That was painful. That hurt.
Yes, sir.
Thank you. Good morning, Mr. Spindler.
Mike Spindler's back.
Good morning. Can you remind the jury who you are and what you do?
Yes, I'm Michael Spindler. I'm a forensic accountant. I'm a CPA, a certified fraud examiner, amongst some other certifications. I'm with B. Riley Advisory Services, a national firm that does forensic accounting, bankruptcy and restructuring work, and business valuations and appraisals. I've got over 40 years of experience.
Are you familiar with the testimony rendered by Ms. Arnold in this matter?
Yes, I am.
Do you understand that Ms. Arnold testified that Ms. Heard has suffered economic damages resulting from 3 statements made by Mr. Wall?
Yes, I do.
Do you have an opinion of that claim?
I do.
All right.
The petition's at 4.3 million, and the goal was to get it to 4.5 million. It's almost there. Wow. This is about removing Amber Heard from Aquaman 2. Yikes.
What happened here?
Did someone get kicked out?
No, they're sidebarring.
Oh, okay. Somebody just got up and walked out. That's all. Okay.
I think this is
As
the
soon
most
as they
angry I've
asked for
seen
his
the courtroom.
opinion on Arnold's testimony.
Man.
So it's Joe who got kicked out.
No, Joe's not there today.
The petition's almost
think,
at
right?
4.5 million
Oh, it's
to
funny
kick
'cause his
Amber Heard
proposal
out of
was
Aquaman 2.
Yesterday. Oh no! Yesterday he was there, but he told us that
Mitch?
he was going back. He was going back to New York last night. That's what he told us, anyhow.
Wow.
Likely story.
Yevgeny likes the maritime lawyer.
Hey,
Здравствуйте, Евгений. Как дела?
привет, давай.
That lawyer knew his stuff, man.
That's what they say.
The
What
Hollywood lawyer
could
knew
the
his
sidebar
stuff.
possibly be about after the question of do you have an opinion regarding his opinion?
Beyond the scope of his disclosure. Be my
But then
guest.
what I didn't read the disclosure, I must admit.
Objection, he's about to say
Thanks, Mr.
something
Spindler.
bad for our case.
Now, you indicated that you
Yes,
had
sir.
listened to Ms. Arnold, and she testified on behalf of Ms. Hurd relative to economic
It was
damages.
foundation.
Have you formed an opinion as to the testimony and opinion rendered by Ms. Arnold?
Yeah, that's what I.
Yes, I have.
What's that opinion?
What a waste of
It
time.
is not adequately supported and it is unreasonable.
Boom.
But what's your real
Can you
opinion?
tell us how her
There were
methodology
multiple
is shit?
elements to that analysis. Both damages that related to her film career and to endorsements. Have you analyzed both those issues?
Yes, I have.
What is your opinion of the claims that have been asserted?
For those who are
relative
wondering,
to the film
these
career
people
and
who are testifying now, these are rebuttal witnesses. They've
Okay,
already
well,
testified. Some of them have already testified.
First of all,
like
with
this
respect
gentleman
to her damages
and the
calculation,
previous
there was
attorney.
no calculation per se.
This guy
Um,
is an accounting
She
guru,
initially
essentially.
looked at these comparable actors and seemed to use that as a basis for numbers. She didn't provide
He knows the
underlying
numbers.
calculation. She didn't provide underlying support. And then it appeared as though in her testimony, she backed away a little bit from that, but she still suffers from the issues of not providing detailed calculations or support for where those numbers come from. And she still, to some extent, appears to be using some kind of comparable analysis.
All right. What is the type of analysis that you think is appropriate here?
Well, I think, and as you heard from the last witness, I think that something that is anchored in facts, taking a look at historical compensation as a basis for
Anchor
anticipated
in
future
fact.
Had you looked at Ms.
Forensic
Hurd's
accountant, that's right.
prior compensation?
Forensic accountant, thank
Yes,
you.
I have. I've looked at tax returns that were provided for the period of 2013 through 2019.
Why do you want to use historical earnings?
Well, once again, you want an analysis that's anchored in fact. I don't believe that Ms. Arnold has done that in her analysis. So here we've got some actual data. We've got some historical compensation.
He'll have some
And as
probably charts and graphs.
Last witness mentioned, that often provides somewhat of a basis for future anticipated earnings. In addition, I believe that Ms. Arnold herself said that she had hoped to be able to look at a renegotiated salary for Aquaman 2 and then use that as a basis for future compensation, that being the new kind of base, if you will.
All right. Were there any years in particular that you focused on in your analysis as to Ms. Arnold's testimony?
In terms of the historical compensation?
Yes.
Well, for 2013 through 2019 in total, her compensation was around $10 million for all those years combined. In 2019, the last of those years, her compensation was somewhere between about $2.6 million and $3 million. Now, that's a good year. That's known as a clean year.
What do you mean by a clean year?
Well, for example, 2019, you had Aquaman was released in December of 2018, and that was a successful film. So in 2019, you've got the benefit of that kind of success, and you also don't have any potential impact from the alleged defamatory Waldman statements that occurred in April of 2020. So 2019 is clean of all that.
What did you understand Ms.
Good
Arnold's
explanation.
methodology to be?
Her methodology,
Make it up as she goes.
initially, appeared to be based on these comparable actors that she had identified. And theoretically, the compensation that they earned, although she doesn't identify what that compensation is or provide any support for it or any calculations.
What is your opinion of that methodology from an accounting perspective?
That methodology was unsound. It's just unsupported. There are no numbers. There's no data that she provided and support for that.
What methodology did you understand Ms. Arnold to adopt at trial?
Okay, well, it looked like somewhat of a mix and match approach. She used different approaches, I believe, for different elements of the damages, although it's still a little bit unclear to me, a little bit vague. But there are 4 basic components that she was looking at, and we can go through those in any order you wish.
All right. With respect to the television
For those who are
series
wondering why
portion of her
Amber's lawyers
analysis,
team isn't
what
taking as
do you
long
understand
in their
about that
cross-examination.
methodology to be?
They have less than
Objection,
4 hours left of actual
What a
time
great moment it would have been for a what
to
if
do
any methodology.
cross-examinations.
Oh,
They got to be very
Huh.
judicious with their
if
time.
any. Let me get a super chat question while we're here. Melizabeth B. In defense of Dennison V. Vasquez, she sometimes comes off too harsh, so having someone more bumbling a little is a good strategy for balance. Thoughts? Love you all. Keep up the good work. Yeah, it could be.
Good cop, bad cop.
I think the attorney would take that as an insult, but okay.
Funky Anouk says, do you know anyone who is familiar with Japanese law with any social media? The foreign community here is desperate for someone to explain some
Yep.
basics. I don't know anyone, but if there is anyone out there that is watching that is able to fill that gap, sounds like you've got a market.
Well, it depends if there's any, like, if it's a specific legal question. If someone DMs me, I can hook them up with some of the lawyers in Japan that we work with regularly, just being right across the ocean from us. But if it's just like someone needs some basic background information, then they may not want to do a consultation with the lawyer. But again, if it's a problem, if it's an issue, I can hook them up with the lawyer in Japan if they need.
All right. Awesome. Thank you. Penguin Chili says, when Elaine says, what if any, to get around objections, what better ways can she do that? It's so triggering when she says it so much. Frame your questions starting with who, what, when, where, how, why. That's generally how you should go about it, and mix things up. You can have what if any, just don't do it for every single damn question.
I would say start from the standpoint of asking whether what you're trying to elicit is even admissible, so you don't draw hearsay and foundation objections that you have to try to skirt with cute little wordplay.
Yeah, agreed. Fangirl Justice says, possible to put a text box on the screen with the name and description of the witness expert while they're on the stand. Hard to follow why they're even here. Well, we do have the name of the witnesses linked in the pinned comment in the chat. So, along with a small description when we can get it. So that I hope that answers your question there. Gemma Pint says, is last witness for Amber Heard regarding damages? Can they drop a witness if it seems jury have checked out on this subject? Love you all from Scotland. Well, it turns out they didn't actually have
checked out on a lot of stuff.
Evaldia says, if Amber Heard can justify using hashtags for damages, doesn't that also mean that JD can use hashtag #MeToo and similar for proving damages and as a cause for Disney to cancel him from any further Pirates movies? I would think so, but the logic that she's using is not very sound, so I don't think he wants to use unsound logic, even if it's for him. Library of Maury says, can Amber Heard on appeal submit new evidence, i.e. pics? No. It's appeals are made on legal arguments, not factual arguments. So the trier of fact is the jury here.
Yeah, when
not
you file
an
an appeal, you have to prepare a record and provide it to the appellate court.
Exactly. Yeah, exactly.
She can rely on anything that has been filed in court, anything that has been stated in court that's reflected in a transcript. An
Right.
appeal is a review process. It is not a re-litigation or reopening of the issues. It's just evaluating whether Judge has karate committed legal error at any point.
Right.
Yeah.
And that's why the judge is so
Age
careful.
is driving her team strategy against their advice. Probably.
Yes.
That's what it looks like.
That's
Paulina, can you read this? I live in Brazil, Sao Paulo State City, Aguas de Lindóia, I think, maybe?
Nice.
I don't know
Earnings
Portuguese,
from
but hopefully I got that right.
shows. Did you analyze what historical earning Ms. Heard had during the period that you were concerned with relative to television shows?
Well, yes, during 2019, she entered into a contract in July of 2019 to appear in a television series at $200,000 per episode.
What about endorsement deals? Did you look at what she had made on endorsement deals during that period?
She did have a contract with L'Oreal at $1,625,000.
All right. With respect to her movie roles, what were her historical earnings during that period?
Well, certainly for the most recent years, you had the Warner Brothers deal, which was a 4-picture deal. The first film was $450,000. Then the first Aquaman was $1 million base fee. Then $2 million for Aquaman 2. And presuming that there was an Aquaman 3, that would have been $4 million.
Okay. Why do you look at historical earnings as part of your analysis?
Because you want your analysis to be anchored in facts. You want it to have a sound methodology, and you want to come up with a reasonable result.
Right.
So if you take a look at,
That just
for
makes sense.
example, the analysis that Ms. Arnold did, it didn't appear to be.
Let's just look at the analysis that you're doing. What you said, I think, is you wanted them anchored in facts. Why?
Because that provides a sound basis for coming up with something with reasonable certainty. There's AICPA, or American Institute of Certified Public Accountant guidance with respect to reasonable certainty. And those are the basic elements of it.
Thank you. No further questions.
All right, cross-examination.
By the way, Jeff, I think this petition, instead of 4.3 million, is going to be about 4.5 million, if not by the end of the
How are
day.
they going to try to
For sure by the
pass
end of the week,
this?
Good morning.
before Friday.
I'm going to ask you a few questions that may refer to the statements in Amber's counterclaim against Mr. Depp. When I refer to those statements, I'm going to refer to them as the Depp-Waldman statements. Do you agree?
Why?
That we can both be on the same page
No,
what I'm referring
no,
to?
don't do it. Don't.
That's fine. You can use your terminology.
I'm sorry, there's an objection, sir. Hold on.
Can we approach?
Okay.
Yeah.
There's not the
Thank you
Jeff
for
Waldman
objecting today.
statement.
You should have
Thank
objected to
you.
that yesterday too.
Yeah.
There was no
Weasel.
examination on that. This is beyond the scope of that. And then he's introducing this unfair characterization.
Right. Fucking weasel. Excuse my language.
Like he's trying to
Weasel.
get him to agree with a legal conclusion, essentially.
It's such these little edges that lawyers try to get with non-lawyers. It's just so
And
funny.
this really is something that the Depp team, that guy, especially Dennison, just did not. He was.
I mean, also, I wish that they would
He
have
should have
prepared him for
objected to that yesterday.
I wish that they would have prepared all of their witnesses for that, to say, if they try to get you to agree to that these are Depp Waldman statements, say, my understanding is that these statements were made by Adam
Correct.
Waldman.
The thing that's killing me with these experts is I'll just take your word for it. No. Prep your witness to never take their word for it, ever.
Yeah.
Exactly.
Yeah.
So, Mr. Spindler, when I refer to the Depp-Waldman statements, you understand me to be referring to the statements in Ms. Heard's counterclaim against Mr. Depp, correct?
I'll understand that, yes.
Now, you're here to provide a
Ugh.
rebuttal
Prepare your witnesses,
opinion
guys.
to Ms. Arnold's part of Ms. Arnold's testimony, correct?
Correct.
You're not providing opinion on whether Ms. Heard suffered defamation by Mr. Depp, correct?
That is true.
You're not offering an opinion as to what any of the underlying facts relating to whether Mr. Depp abused Amber, correct?
That's correct.
You're not offering an opinion as to the magnitude of damages that you believe Ms. Heard may be entitled to if she proves defamation by Mr. Depp. You're just reviewing what Ms. Arnold has said, correct?
That's correct.
And you said that you want your analysis to be accurate in facts, right?
Anchored in facts.
Anchored in facts. You'd agree that what an actor earns in one period isn't necessarily reflective of what he or she may earn in future periods, correct?
Correct.
And that's because
there can be some variability.
An increase in the number of roles may lead to greater income, correct?
I'm sorry. Could you repeat that? I was speaking. I didn't hear.
One of the reasons that what you earn in one period may not be reflective of what an actress may earn in future periods is because an increase in the number of roles may lead to greater income, correct?
the number of roles or the particular project itself, yes.
Sure, getting better roles may lead to greater income, correct?
Correct.
And the same is true for an endorsement. As an actress's profile grows, the amount of money that she may be able to earn from endorsements grows as well, correct?
It can.
So
It depends.
what Ms. Heard earned from, say, 2013 to 2019 that you testified to isn't necessarily reflective of what she might earn over the next 5 years, correct?
Not necessarily. It is a good indicator, though.
And you'd agree that from 2013 to 2019, in terms of earnings and star power, that Ms. Heard's career trajectory was on the upswing, correct?
There was a slight increase during that period of time in her earnings from 2013 through 2019.
And you'd agree that that was as a result of getting more lucrative roles, right?
Yes.
Yeah, this is all
But you're not a
designed,
causation
Jeff, to
expert,
just get
right?
yes or no answers or
That's
correct.
So you're not
That's all it's
testifying as
designed
to
for.
whether the Depp-Waldman statements caused her to lose any roles, correct?
That's correct.
And you're not offering any opinion as to whether the Depp-Waldman statements kept her from being considered for
Lazy
roles
ass
that she
fucking
otherwise
lawyer.
would have
The
been
Depp-Waldman
considered
statement.
for, correct?
That's correct. I'm not testifying on causation issues.
And you can't speak to what opportunities may never have materialized for Amber as a result of the
No, that would
Depp-Waldman
be
statements,
speculative.
correct?
Yeah, I've not done those calculations.
And you don't have an opinion about whether or not Ms. Heard could have renegotiated a contract for Aquaman 2, correct?
That was not part of my work.
And you don't have an opinion on the impact that additional exposure or press coverage or magazine covers or interviews would have had on Ms. Heard's career, correct?
Correct. I'm just looking at Ms. Arnold's calculations.
You've never served as an expert witness before to calculate damages based on lost roles by an actress resulting from defamation against that person, correct?
I've been involved in defamation cases, but I've not done the calculations as an expert witness and testified thereto.
And there's never been an instance in which you have served as an expert witness in a case to calculate damages based
Her fake
on
cheekbones look pretty good for a 36-year-old woman. It'd be
Correct.
funny to see what those look
And
like
you're
when
not
she hits
offering any
46.
expert opinion on what impact the alleged defamation by Mr. Depp has had on Ms. Heard's career, correct?
I'm sorry, one more time?
You're not offering any expert opinion on what impact the Depp-Waldman statements by Mr. Depp has had on Ms. Heard's career, correct?
Other than taking a look at Ms. Arnold's calculations.
And you're not offering any expert opinion about what impact, if any, social media coverage of this case or of Ms. Heard may have had on Ms. Heard's career, correct?
You're correct. That's other experts.
Can we approach
No
her?
further questions. Thank you.
All right.
Okay.
I don't know what that was about.
He completed questioning without an objection. I don't know why we're approaching, but okay.
All right, thank you, Ms. Spindler. You can have a seat in the courtroom.
Oh,
or you
no
can be ready to
redirect.
go. Thank you.
No redirect.
All right, your next witness.
Power move. I mean, because yeah, what did he do?
Plaintiff calls Doug.
I like the very strong
Spell last
narrowness
name.
of that question.
B-A-N-I.
Have you ever testified as a damages expert in a defamation case relating to a female
Involving
lead?
Amber Heard and
That's
Johnny
oddly
Depp?
specific.
Have you ever done that before?
I was like, that's a
How could
very
you
narrow
possibly
question,
know?
Yeah,
counselor.
that was
It
oddly
was
specific.
either a mermaid or in an Aquaman movie.
Yeah.
Yeah.
Sir, have you ever sat on a rocket ship that went to the moon and then circled around and then came back after several days?
That's about what it sounded like. I'm being an expert. I'm a smart
All right,
ass.
which witness is
So
this?
I'd have probably said that's
Albania.
oddly specific, but
Ah.
okay.
Okay.
Who is this guy?
So you can.
Oh my gosh, he was the terrible guy with the
So just a
charts
reminder,
last
you're still
time.
under oath. Okay, sir? Thank you.
Why did they bring him back? He got destroyed on cross-examination by Amber
Good
Steen last
afternoon, Mr.
time.
Banya.
Good
I
afternoon.
like Amber's
Can you
ways of
briefly
saying.
reintroduce yourself to the jury, please?
Yes, hi, Doug Banya. I am from Nevium Intellectual Property Consultants based in San Diego. I value intellectual property. I provide
He was
litigation
terrible last
support,
time.
in
Terrible.
infringement and defamation cases, as I'm doing today. And I use internet and social media analytics and both of those services.
Any of y'all work in Q scores
Since you
before?
last testified in this case, the jury has heard testimony from Ronald Schnell and Catherine Arnold. Are you familiar with their testimony?
Yes.
Were you asked to analyze their testimony and provide opinions in response?
Yes, I was.
Have you formed opinions in response to the testimony of Mr. Schnell and Ms. Arnold?
I have.
Generally, what are those opinions?
Generally, Mr. Schnell provided no evidence of a correlation between the Waldman statements and the hashtags and the spikes of those hashtags on Twitter. Second, based on my internet and social media analytics investigation, I've concluded that the alleged comparable actors that Ms. Arnold came up with are not comparable with Ms. Heard. And then thirdly, Mr. Schnell.
He sounds good at first. Let's see what he sounds like on cross-examination.
Failed to provide any evidence of a causation as it relates to the Waldman.
He sounds good now. Let's see what he sounds like on cross-examination. That's where he got
economic harm
tripped up last time.
Let's dig into those opinions a little bit. You're familiar with the testimony of Mr. Schnell that there are more than 2.7 million alleged negative tweets related to Ms. Heard between January 2018 and June 2021?
Yes.
And what's your understanding of how Mr. Schnell identified those particular 2.7 million tweets?
Yeah, so essentially Mr. Schnell chose hashtags that he felt were negative towards Ms. Heard. Those hashtags range from justice for Johnny Depp, Amber Heard is an abuser, Amber Turd, and the hashtag we just don't like you, Amber. So then
never get tired of that Amber Turd with me. That's hilarious.
Through using the Twitter API, searched through various tweets, and then came up with any tweets that were using those hashtags.
Did you conduct an analysis of those tweets?
Yes, I was given that exact the data that Mr. Schnell used on a hard drive. So yes, I dug into that data as well.
And what was the purpose of your analysis?
So what I'm trying to do, and what's at issue of the case today at this point, is were these tweets contain the Waldman statements? That's what where we're at right now, are the Waldman statements. So I wanted to analyze those tweets to determine which ones, and if any, contain the Waldman statements.
And what's your understanding of what the Waldman statements are?
So my understanding is there's three Waldman statements that were published in the Daily Mail.
Not allowed to play video games. As I understand it, he's doodling, he's just drawing, and he probably is bored.
Arnold,
I'm sure the jury is too.
Was quoted in three of those articles. And those dates were on April 8th, 2020, April 27th, 2020, and on June 24th, 2020. And my understanding that those quotes, sorry, I think I said the wrong name, but those quotes are the only remaining in this case.
Did you analyze the timing of the tweets that we were talking about as compared to the timing of the Waldman statements?
And that's exactly what I did. So I wanted to look at the Waldman statements, look at the dates that they happened, and then analyze those as compared to the Twitter data that I had.
Have you prepared a demonstrative that reflects that aspect of your analysis?
Yes.
Your Honor, may I approach?
Yes. Bishop Counsel.
Okay, this is the guy. I just didn't really care for this guy last time because he sounds good at first, right, on the direct, but when the cross-examination got up there, ate his lunch on the redirect.
He has not yet come up yet today.
I mean, on the cross-examination, because it just
still
came down
young.
his
We haven't
charts,
had lunch
didn't
yet.
mean anything.
For the boogeyman to
I
come
don't know
out.
if I'm going to keep doing this, by the way, after lunch. Probably when lunch breaks, I'll have a few statements to make, and then we'll probably wrap it up at that point.
Was worth it already.
But I would love to
Yeah.
see
I
Amber's
think this
team
is
run out of time. I just
success.
don't think they're going to today.
I don't know what the foundation
Because
is.
they're being very quick about their cross-examination.
Talking about.
I really want them to be bringing in Amber Heard's Wald Mignon tweet that launched the
Amber's
hashtag of the
teacup
Wald
dog
Mignons
did not
that they're
do
now
that
trying to
poop.
say is
That
the
was an
Waldman's
Amber
fault.
poop. That was an Amber-sized poop, brother.
And can be published to the jury.
Everybody's been making fun of her crap in the bed, both literally and
Mr. Banya,
figuratively.
can you explain to the jury what this demonstrative shows?
Yes. So this shows the total hashtags and tweets that Mr. Schnell was analyzing. This is the summary data that their tweets that are running from January 2018 to June of 2021. And again, these are related to the four hashtags that I discussed. Whenever I get an assignment such as this, when I'm dealing with a defamatory statement that's allegedly gone viral online, where there's economic damages involved and there's a lot of data involved, I like to take the data and I like to do a 30,000-foot view of the data to see what I'm looking at, to see if there's anything interesting, odd, different about data. And the first thing that I noticed is 35% of the tweets were prior to the Waldman statements. So again, remember, my assignment is to determine if the Waldman statements are part of the tweets that Mr. Schnell analyzed.
Well, so much for that.
So obviously, if these tweets were prior to the Waldman statements, in no way could they have anything to do with the Waldman statements. So that was the first issue that I noticed. Then I noticed what I like to call kind of the alleged defamatory time frame. And as I discussed, that's when the Waldman statements were published. That's the date down here. You know, the first one was in the beginning of April, and the last one, which is the third
Sorry,
one, was
Tom.
at the end of June. But what I found interesting is only 2% of all of the tweets happened during this Waldman statement period. So really, these are just observations. And for me, there were red flags that I made note of. And then I just continued with my analysis.
What other work have you performed in connection with forming your opinions about the purportedly negative tweets?
Yeah, so now I realize that 35% are irrelevant and
I agree.
2%, only happened during this important period. I just continue to dig into the 2.79 million tweets that Mr. Schnell provided.
And Tom, can we take that one down? And Mr. Banya, have you prepared another demonstrative that depicts that analysis that you were just describing?
Yes.
Okay. Yes. Okay. We'll just see if he has them.
Look at another chart. Let's look at another chart.
No, I'll give you time to look at it, sir. All right, plaintiffs, you can turn on your microphone, sorry.
No objection as a demonstrative.
Okay, all right, plaintiffs exhibit 1294 will be marked for identification as a demonstrative and will be published to the jury. Thank you, Your Honor. Mr. Banya, can you explain what this demonstrative shows?
Yes, this is showing the various spikes as it relates to the hashtags that Mr. Schnell testified about. This is actually an exhibit or a demonstrative that he used in his testimony. What this is showing are the largest spikes related to the hashtag Justice for Johnny Depp. I don't know if you remember his testimony or any of his demonstratives. The other three hashtags did spike at the same time, but a very small spike. So what I'm showing you here are the 6 top spikes in Mr. Schnell's analysis. And what's important here again is the very first spike and the largest spike again happened before the Waldman statements. So what I'm trying to figure out is what tweets were related to the Waldman statements. So this number 1 spike, which is the biggest spike was prior to the Waldman statements, so it's irrelevant to the case. And then the second thing I noticed that was
That's some good
interesting
data.
here is here are the dates in gray right here. This is the time in which the Waldman statements happened. And you're going to notice, as we discussed before, only 2% of the tweets happened during that time. But I found it very interesting for such a viral event that has potentially caused such economic harm. There's no spikes in this area. And actually, you're going to see that Mr. Waldman, his statement came out here in the first April 2020 article. Then the second one came out here. And then the third one came out in June. There's actually a downward use of the spike, downward use of the hashtags. So I'm not seeing any correlation as it relates to the Waldman statements and any spikes here as it relates to the hashtags Mr. Schnell chose.
Did you analyze each of the spikes that are depicted here?
Yeah, so what I did is I looked at the 6 different spikes, and you're going to notice that each spike represents a month. So
Good one,
the
Sean.
second spike, is July of 2020, and so on to the 6th spike going to April 2021. And what I did is, I don't know if you remember my last testimony when I went into Google search, and I'm able to go into Google search. I went in and I typed in Amber Heard. And then after you hit search, you can use the tool and you can go back in time. And I chose each 6 of these dates to go back in time to see what was the media talking about back then. What was the general public being fed as it relates to Amber Heard back during those spikes. And what I found is none of them, well, actually I analyzed the top 3 search results because they represent 50 to 70% of what people click on. And I realized that none of them had anything to do with the Waldman statements.
Probably half of them were bought.
Mr. Schnell's testimony that the tweets
At least,
using the
maybe
4
more.
hashtags he looked at were mathematically correlated.
Yes.
What does that mean?
So what Mr. Schnell is saying, which is irrelevant to this case, is the 4 hashtags that he randomly chose.
Yes, Viking
They,
Rex.
they tend to
He's
go up
redeeming
and
himself.
down together, and that's why
So far.
he had these spikes here. So the correlation there is how those 4 hashtags work or dance together going up and down. But first of all, the hashtags have nothing to do with the Waldman statements. And the fact that there's a correlation with the hashtags is irrelevant to this case because we're dealing with the Waldman statements, which none of that correlation analysis he did had to do with.
How do you know that the correlation doesn't have anything to do with the Waldman statements?
Can I clear this at all? No. Oh, yeah. Well, first of all, I know because that would happen right here. If when Mr. Waldman, one of his quotes was published, you would see a big spike right here. And then you would see maybe a little noise down here. And then the third time you might see second time a big spike, and the third time a big spike. That's not here. So that's telling me there's no correlation between the Waldman statements and this hashtag use. And then I've actually provided evidence that there's no correlation because I analyzed each of these spikes and none of them had to do with the Waldman statements.
Is mathematical correlation the same as causation?
No.
Why not?
I mean,
Good.
Correlation is simply
Correlation does not equal causation.
Between 2 or more variables or 2 or more things. In this case, the correlation question is: when the Waldman statements were published at the same time, did you see a correlation with spikes in these hashtags? And again, can we clear this? You see none of that right here. It's actually a downward trend. There's no spikes, there's no correlation. So, again, Mr. Schnell provided no evidence of any correlation.
What correlation opinion did he provide during his testimony?
Well, he provided the correlation that the 4 hashtags, spike together. But again, the hashtags have nothing to do with the Waldman statements, and the facts that they're correlating or moving together is irrelevant to the case because the case is about the Waldman statements.
So what is causation then?
So causation is where one thing causes a change in the other. So as it relates to this case, did the Waldman statements cause Ms. Heard to have economic harm? In other words, did the Waldman statements cause Ms. Heard not to make as much money in her career? And again, Mr. Schnell provided no evidence of this. Ms. Arnold provided no evidence of this. And as a matter of fact, during Ms. Arnold's testimony yesterday, she didn't even know what causation was. She was asked, do you know the difference between causation and correlation? And she said that she's not a semantics expert. We're not talking about the words.
That was a good moment.
Damages, you have to prove causation prior to calculating damages. So there's no causation that's proven here. Therefore, a damages analysis is not appropriate.
Did you hear Mr. Schnell testify that he agreed with your opinion in this case?
Yes.
And what's your understanding of the opinion that he agreed with?
Well, he agreed that he failed to link the spikes in the hashtags on Twitter.
I wouldn't doubt it.
To the Waldman.
Most of these people live on the left coast,
He tried to do that.
including Johnny and Amber.
Well, again,
Although Johnny
his
spends a lot of time in
analysis
Europe
was
and England.
looking at the word Waldman and looking at the word Waldmanian, and then trying to say that 25% of the tweets included those two terms. But first of all, Waldman isn't the issue here. It's the Waldman statements. And Waldmanian, I don't even know what that is, but it's not relevant to this case.
I love Twitter hashtag analyses.
Please, Tom. Mr. Banya, what other work have you done in connection with forming your opinions about Mr. Schnell's testimony?
Again, the assignment was to determine if the Waldman statements were part of the tweet. So I continued to dig in, to the data. I believe the next step is, now that I've excluded, the 35% that was before the Waldman statements because they're irrelevant, I wanted to really analyze from the April 2020 forward to see if any of those tweets, contained the Waldman statements.
Did you prepare a demonstrative that reflects that analysis that you did?
Yes, I did.
Your Honor, may I approach again? All right, let's move.
More documentation.
Oh, come on. We didn't figure this out last time.
Okay, well,
I mean,
let's get another
sounds
question.
good. I don't like this guy on cross.
L says
I'm
if
just-
age
I don't
loses-
like him on cross.
No objection as a
Never mind.
All right, we'll mark it for identification as plaintiffs 1295 as demonstrative.
Do you guys there?
So, Mr. Banya, did you consider the content of the statements made by Waldman as part of the work that you did?
Yes. Yeah, so here I reviewed the Waldman statements again. And what I wanted to do is I wanted to determine what, if any, tweets included the Waldman statements. What I went back to the Waldman statements, and I came up with key terms and key themes for those Waldman statements, which are listed here.
Abuse hoax, sexual violence hoax, fake sexual violence.
Sexual violence hoax, and fake sexual violence. So what I did is we're now dealing with a 1.2 million tweets because we're starting in April 2020 because that's when the Waldman statements started. And what I did is I searched the 1.2 million tweets, for these three phrases. And I determined that there were 751 tweets that included those key terms, which is 0.06% of the 1.2 million. And then as I was sifting and sorting and analyzing this data, I realized that a lot of these tweets have the exact same language. It was interesting to see it was the exact same tweet because I'm analyzing the language to see if it matches one of these three. I realized that a lot of these tweets were retweets, likes, or shares. So therefore, I eliminated any of those, and it came down with 95 unique tweets.
Okay.
And then what I did from there is I analyzed those to determine if any of these terms were in there, and I identified 5 tweets that were related to the Waldman statements.
Do any of the hashtags Mr. Schnell analyzed include the words from the Waldman statements?
No, they don't. And, because I am rebutting Ms. Arnold, her testimony yesterday, she was saying that the Waldman statements caused these hashtags. Then throughout her testimony, she walked that back and admitted, no, none of these tweets have anything to do with the Waldman statements. They don't include the Waldman statements. These hashtags are only hashtags that Schnell, in his opinion, felt that they were negative towards Ms. Heard.
Based on your
There you go.
expertise, what are your overall opinions about Mr. Schnell's testimony and the Twitter hashtag data?
Mr. Schnell provided no evidence that any of the tweets were related to the Waldman statements. Mr. Schnell, there's no correlation there. He also provided no evidence that there's any causation that, the Waldman statements caused any economic harm towards Ms. Heard.
Your Honor, I'm about to switch to a different topic. I don't know if you want to
I
break down
appreciate
or
the
push.
Friends
All right,
reference,
it's gonna be,
Lara Flint.
A little while, I assume.
A little
Get
bit
him,
more. Yes.
Poindexter.
Let's go ahead and break for lunch, ladies and gentlemen. Okay, do not discuss the case.
Lunchtime. Yes.
Research, okay?
I need to go do the same thing. Very interesting stuff. These guys are going to talk through lunch. If you guys want to listen to them through lunch, that's
WCHW as in
great.
the
I
witness?
appreciate you staying with me.
Waldman. Oh, Waldman. Sorry. Can Waldman sue Amber Heard? No. Nope. Because like I said, there's a litigation privilege. So
Let me do this
all of her
real
allegations
quickly,
have been
'cause I know
made
they're going to be talking
in
on
the
the.
process of a court proceeding
let me
in
get
a
this down.
complaint in open court.
All right, we'll come back at one.
Okay. These guys do great analysis over lunch break. They have like food sitting there and they're doing their own thing. And a lot of times they're off camera, they're probably eating, whatever. They do a great job here. I have not eaten at all today. You guys saw me bite into one of these. And I am very hungry. So I'm going to go downstairs and make a sandwich or something for lunch. I'm going to keep everything up and running. So please stay with them. I'll be back. Just don't want you to guys see me eating on camera. Sandwich won't take long. It'll be pretty quick. But these guys do great analysis of what's taking place so far. I am going to be listening, even though I'm downstairs in the kitchen. I look forward to talking to you guys again real soon. Oh, let me see what Jeff's got going on. Jeff, hold on. Let's see here. Apparently Elon Musk was right about the bot. Yeah, he was very right about the bot. Enjoy it. Thank you, bro. Oh, man, too bad you got to go. Hope you come back. I will be back on in a few minutes. I look forward to talking to you all soon. Stand by.
Motions to strike did fail. As we've said before, it's hard to win on those. It's like really, really hard to win on those. So even though it didn't succeed on Johnny's side, that doesn't mean that the jury's going to come back and decide in favor of Amber Heard. I mean,
yes,
the fact that there was even a good argument to be made there is a clear indication of the idea that Amber's in some serious trouble when it comes to the jury, because I don't see them coming in her favor.
No.
So
On that counterclaim.
No, that counterclaim, I think, was it Rick who said it the best? Like the counterclaim just sunk her case. Just everything.
Yeah.
If she just did not file the counterclaim, it just
I said
let
that.
in so much stuff that is okay. You said that. I'm sorry.
Yeah.
Yeah.
No, that's okay. But
like-
other people probably have said it
Been
too.
a theme
It's
throughout
not an
this
independent
case.
idea.
Basically, from the moment she filed it, what a mistake it was.
Every time I just think of like a witness or like a counter witness, what's going on. I'm like, oh, this witness is here because of the counterclaim. Oh, this is terrible.
Yeah.
I did have one question. Maybe it's a little too in the weeds.
Let's
But
do it.
because I
Let's
thought
do it.
the
Let's
Q
get into
score,
it.
the Q score was real. Q score witness was very good, very convincing. Like it made sense. I was following all the data but he was trying to reduce all the amounts of tweets, right? And he was like, well, we analyzed, and really, it's not 2.7 million tweets, it's 1.2 because it starts at the time the Waldman statements were made. Totally fair, totally makes sense. But then he was like, and then we looked for repeated language and we saw that a lot of them had the same language. Therefore, those are retweets and don't count. But isn't that not how Twitter works? There is, if you retweet it, it is still one tweet, right? So the duplicative language tweets are separate tweets. They're different accounts tweeting the same language, which in my mind doesn't mean you can cut those out, right?
Were they differentiating that way? I mean, maybe I missed that.
Well, he didn't explain it that way, but he said, he was like, then when we analyzed it, there were all these tweets that had the exact same language in it, and those were what we called likes, shares, or retweets. And then he deduced it down to 95 unique tweets, which to me, I was like, I mean, maybe, look, I don't, you know, I'm not a social media,
I had the
that's not my
same
industry.
thought.
But that was very weird to me. That seemed like it was the one part of his
I had the same
logic trail that all of a sudden had me like, oh, it sounds like you're
So-
trying to just reduce the amount of unique tweets.
So maybe that's what exactly he was saying.
Yes, but his methodology is transparent.
No,
at least.
absolutely.
Like that's what I liked about it. He's saying this is what I did, and if you retweeted it, didn't count. Now, if you think you should count it, but that's what I did. So
Yeah, no, that's
in that sense,
totally
I thought
fair.
it was very strong.
Yeah.
Oh, absolutely.
So
No, he was
yeah.
very strong testimony. I was just really riveted by his logic and trying to follow it. And that was like the one break in the chain. I was like, wait a second. You know, but
Well,
other than that,
that-
I
absolutely.
thought the same thing. I'm
That
like,
does
well,
seem
why?
like
Well,
a
he's a lot
potential
better now.
avenue for cross-examination because I mean the argument I guess would be that the retweets drive the engagement, they drive the impressions. More people are going to see it the more it's retweeted, and so then the more effect it's going to have on people's perceptions and stuff. So it's
Right.
possible they could come after him on cross with that if they caught it.
And it just depends on whether or not that's how he was even analyzing it. You know,
Yeah.
like it's such a down the weeds thing. It could have been that all of those duplicative languages were each retweet was being counted separately.
I mean, that's what it
Maybe.
seems like now that you explain it back to me. That seems like what he was trying to say. That, you
Yeah.
know, at the end, there were 95 unique tweets
Mhm.
and everything else was a retweet, share, whatever.
Yeah,
So-
it's possible. And you know what? And like what chat's saying right now is they're like, look, that in the end, that part of the analysis reduced it from 725 unique tweets to 95 or something. Like, so like
sounds
really, is
plausible.
it going to be that much of a difference? Right now, Amber is scrambling to actually try and win her counterclaim at all, let alone like prove maybe whatever $50,000 more in damage. So it's probably
Yeah. And by the way, this is a great reminder from this super chat. Kurt is almost up to 85,000 subscribers.
Thank
Is he
you.
going to be the next one to hit 100K? Is he? I think he
I
should.
always appreciate all your support. Thank you.
Of course. And I want to remind everybody that this live stream is what it is because of the lovely people that come and join in and give their commentary. I would not be able to give all of these voices and all of these perspectives by myself. And these lovely people are donating their time essentially to come and hang out and chit chat with us and give their thoughts and their coming from their expertise. So if you guys do really appreciate it, one thing you could do is, of course, like the video. That's the easiest thing you can do. But another thing that is super easy and really, really effective is to actually go into the description below, find the list of folks that are in there, click on those names that are hyperlinked, and go to their channels, subscribe to their channels, watch their stuff, and like all their videos and all that kind of stuff because it helps to maintain the entire community and helps us all grow together. This is a fantastic community with robust discussion. We don't always agree. We typically learn through the ways in which we do disagree. And so it's wonderful. It's a lovely community to be a part of. I am so thankful to be a part of this community. And I just want to see it grow as well. So please do subscribe to everybody and like all their videos and all that kind of stuff. And also Ankit Bhattacharjee, I hope I'm pronouncing that correctly. Thank you for the very generous super chat. So yes, anyhow.
And thank you for that statement. I just in the very short time I've been here, I got my little bump up over to 5,000. So Kurt, I'm coming for you. Only 85,000 more, and I'm there.
There you go.
I'm going to shill for Kurt too because I don't think most people realize this. If you go over to uncivil law, they're singing. I mean, that's part of the mix. And,
yes.
And it's fantastic.
They're singing, and there is. I mean, his brain will make your brain grow. Seriously, like I've said this so many times that like his is a big brain channel. You can go to some channels that are more, like I feel like on my channel you can get more of the feels, more of the empathy vibes and stuff like that. But like over at Kurt's channel, what you get is legitimately big brain growth, because he really teaches you like constitutional law, coming out with appellate law. You've got the Supreme Court that he analyzes all the time, and he really does take it from a very rigorous perspective. So if you want to really understand some of the more serious parts of law, go to Kurt's channel and subscribe over there and watch his stuff, because you seriously will learn a lot over there.
Yes, upcoming on my channel probably this weekend, when I have time, we'll be doing coverage of the recent decision from Ted Cruz versus FEC dealing with campaign finance decision that came down. Really interesting split on how the court came out on that in terms of campaign finance regulation. And we'll also be covering the case that just came down on habeas petitions in federal court using new information. And the Supreme Court says you can't. Basically, you have to rely on what happened at the state level proceedings. So two fun decisions that are coming down. And of course, at some point in the relatively new future, we'll have everyone's favorite case they're waiting for, Dobbs.
Oh yeah.
Nice.
Hey Kurt, can I ask a quick question?
Yes.
Can I get a preview? Do we disagree on the outcome of the habeas case?
I don't know. I haven't read it yet.
Legally, no. Principally, yes.
Okay, that's fair. Yeah.
Yeah,
The Truth Doctor show. Also, I wanted to point this one out. She's in the chat. Truth Doctor, you've also got a link if you want to come and join the panel at some point today too. But she says, I'm new to YouTube this year, and honestly, I'm officially in love with Law 2. Happy to have met you all. P.S. I'm a big Kurt fan. Yes, awesome. I'm so happy to have met you too, Dr. Tracy. It's been an absolute pleasure having you on the channel and chatting with you, and I would love to have you on again. I know that there were a lot of questions that we got on psychology before that we could not get to before. So anyhow, yeah. Also, Mike, are you almost at 50,000? Where are you at?
I'm 43 and change here.
43 and change. Okay.
But come on over to my channel. You are in no danger of learning anything at Law Talk. I can tell you that right now.
I highly doubt that. You've got to have some educational content on there too. That is hidden as entertainment, right? I mean, that is like the goal, right? It's to like basically like put in some vegetables into the dessert somehow, like sneak them in so that you don't realize that you're eating them.
Zucchini crust. Zucchini crusted. Yeah.
Okay, yeah.
Yes, exactly. Like the zucchini crusted pizza. There you go.
Is the new kid on the block? I mean, what my whole daily deal is, I do most of the stuff at night because it's 2 a.m. here now. But to kind of get my brain going, I do listen to Kurt stuff in the morning when I wake up, because he's either live or has just finished, and that's the fascinating thing. And because just, I mean, from watching his videos and from the brief interaction we had yesterday on Hoag's channel, he's kind of my spirit animal, and that he says the stuff that I need to get my brain ready to say during the day. He opens the path for me to let my inner me out.
That's very, very kind.
Exactly.
I'm just sitting here amongst royalty, so everybody here is just what I aspire to be.
Not me, dude. I haven't posted content yet. Don't. Yeah.
Mark, where are you at without content so far?
Oh, I've got honestly. Okay, you asked. Here's my plan.
Yes.
I've got 3 avenues of weekly series that I'm going to jump in between. One is going to be entertainment law. Just kind of the ins and outs of entertainment law. Kind of start with also classic stuff, Hays Code things, the changes to the Hays Code, kind of all of that. One is going to be analyzing my favorite law review articles, and kind of giving summaries of law review articles that are like, hey, are you a layman, but you want to kind of know what's going on in legal academia? Or like even silly ones. There's, my first one is probably going to be one of my favorite law review articles all time, which I mentioned on stream before, which is called the WWE taking a chair to the head of employment law. And it was basically a note analyzing how they believe the WWE was violating employment laws by having all the wrestlers be independent contractors. right? And so you can go on that and you can analyze that. So kind of that's a little more nerdy. And then I'm in the middle of developing a Warren Court television drama, basically from the perspective of the clerks in the Warren era. I've been developing this for about 5-6 years. Believe it or not, selling a 1950s legal show is not exactly the easiest to sell. But what I'm going to do is I'm taking a lot of research from that, and I'm going to be doing case-based videos on the Warren Court cases in chronological order. So kind of starting with Brown versus Board and really just getting into how the court changed, how they got along, how they didn't get along, and whether or not a lot of their legal bases were solid. You know, spoiler alert, I think Brown versus Board, one of the most important cases of the 20th century. Not going to say wrongly decided, but I'm going to say the legal analysis was garbage, and it was a terribly written case that caused so many problems for 20 years after it was written, because Warren, on his first case, wanted it to be 9-0, but didn't exactly know how to politic creating that sort of consensus with good, sound legal argument, right?
I would say that the reasoning was faulty.
Yes.
In how they got to the conclusion.
Yeah.
Wow, that is ambitious.
So kind of, well, you know, it's the sort of thing I've been reading books on for like the last 6 years, developing the show that no one's ever going to buy. So at least I can make some YouTube videos on it and basically buttress my argument for selling it through a TV show.
Hey, there
First
you
of all,
go.
I want a part on this. I'm not what it is, or nor do I care, but I definitely want a role of some kind.
Oh
Be
yeah,
like a lawyer arguing something.
no,
Be
please.
the
I mean,
bad
come on,
guy.
especially with the Warren Court stuff, because I mean, you're the other constitutional video maker here, and so I think that you and I disagree on a lot of things, which makes for better content.
Like
Great
the Supreme Court
content.
does.
100%. I'm very excited. So guys, if you are looking forward to any of that kind of stuff, you want to learn about that kind of stuff, head on over to Attractive Nuisance, linked in the description below. That is, of course, Mark. And go and subscribe there so that you can be one of the first people to see his very first pieces of content. Remember the other guy who we convinced to start a YouTube channel, and then he put his first piece of content out there. That was Rob. And then he went completely viral. Things can happen. It can be helpful to be in there before somebody actually posts any content. You want to be there for that moment?
Oh, and buy my card game. And buy my card game, guys. That was why originally I even talked with Alita and got her to bring me on the channel, was to show
Well,
me.
the reason why, the first reason is because we're friends from law school. But beyond that, of course, was because of his card game. Yeah, of course. And because he is a great lawyer with a great legal mind as well. So yes.
Well, that description of no content just makes my 50 some odd videos just like utterly useless. I'm just gonna leave now and delete everything.
You build it the real way. All of these people who are subbing to me are just subbing to me because they've been seeing my face, and then I'm gonna make the content, and they're gonna be like, "Yeah, this is really boring. I have no interest in 1954, habeas cases or whatever." So don't worry.
But I mean, you've also talked about doing some on like wrestling and like that kind of stuff too. That has it's a connection point between that and law.
I did develop TV work for WWE and Magic the Gathering, so I'm still trying to figure out the best way to work that in. But
I feel like you're going to have some people that are interested in that line.
Yeah, that's fair.
I'm fascinated in just the. Just this brief presentation sounds fascinating to me.
Yeah, we'll see if I can follow through. Anyway, thank you all for giving me the space, and you guys are fantastic, all of y'all. Why is Mike not at 50,000 yet? That's ridiculous.
He's got to get there. We got to get him there. We will by the end of this week. I feel like we'll get you to 50,000 for sure. But yeah. So. Okay, let's get some super chat questions here, shall we? While we wait, because I don't see any live tweets from Larry, our DUI guy in the room. But when those do populate, hopefully we'll get a notification of that, and then we check those out. But in the meantime, question: if AH loses, or when, if she doesn't have 50 million, how does she pay? Also, say good day. I'm gonna grab a cold one out of the sky with an Australian accent.
She's legally obligated to go back to the poll and work it in tips.
No, that's not true. She's
Hurt.
not.
Here I am singing your praises, and then you just come in hot like that again. What am I?
I mean, there have been rumors about a previous acting type of career or performing career before she was in movies. I have no idea if any of that is true, but people have insinuated as much.
It was on the Depp tape. That was one thing you said during the hysterical laughter tape of her. He said you can go back to the poll. So,
but we also do know that he speaks in metaphors, so that also could have been a particular metaphor as well.
Well, it's referenced in another audio too, a little less ambiguously.
Oh, okay. Well, all right. But anyhow, so if she cannot pay, she cannot pay. They can take her stuff. They can garnish her wages on future movies. If she
can't
does
pay
get
her pledges, she can't pay $5 million if they give her that. She doesn't have any money.
And I don't think that he even cares. I think that
No.
what he wants at the end of the day is for some people to look at him, some objective people to look at him and say, yeah, we believe you. And for him to be able to have that ultimately that I want to say justification, but that's not the right word for it. But basically just to get that result, get that conclusion.
I think that's a good point to. Oh, sorry, Andrew, did you want to?
Oh, I was just going to say, that said, I would not hold it against him one bit if he decided to go 100% balls to the wall, Ron Goldman with his judgment and chase her for the rest of her days for what she's done. Wouldn't hold that against him at all.
Sell off pieces of it to all the really mean debt collectors.
Here I was going to go the exact opposite way. And I was like, I know a lot of us here have been rooting for like a slam dunk. But like, I think when it comes to these civil things, it is really important to remember that what these people have a dispute with each other, and however it is best settled between the two, that the one who deserves justice gets the justice they want, and that is the win, and that should be the win. And I don't necessarily think spiking the football is the well.
This involves the public now.
But there is space for both of those points in the same space, though, right? Like you can say that this is between two people, but also I don't hold it against him if he decides to pursue that money for the rest of her days.
If he wants to Goldman it, he can totally Goldman it. That is totally his right. I'm just saying that if he chooses not to, I don't think that any of us should view that as like just like.
And then he goes a step further and pays the $7 million.
I think his end game is to restore his name, and I think what would make him happier than anything else would be then to get another project, not Pirates, something else, and just kick ass with it, and then he would just walk off and say, "I'm happy."
Yeah, and I think and there is nothing we've seen so far in this trial that would make us think that's not going to be the case. Right.
Yeah. Oh, I saw an article just last week, and of course, these things are speculative, but it suggested that Robert Downey Jr. is trying to get him on with Sherlock. They're, of course, old friends. Robert Downey Jr.'s had his own, problems and redemption story. God, how amazing would that be?
Yeah,
that would work.
Talk about a roadmap for somebody with a redemption story, right?
Yep.
Yeah,
I mean, like that is a good friend to have.
Yes.
Let's get another question here. Natka Neskadova says, maybe I am missing something, but wouldn't it be incredibly silly for Mr. Waldman to publish under his own name? I don't know, but I guess I would go for anonymous link instead. Greetings from Czechia. Well, he was making a statement to the press. They had asked him for a statement on the litigation in the UK as representing him as his attorney. And if you look, you can find that article. If you look at it, the other half of it is them asking for statements from Amber Heard's attorneys and them making statements on the case. So it's like you read it in context and you understand exactly what it is. Like it's not like he's walking around and making statements about like, oh, she's a hoaxer, she's a hoaxer, she's a hoaxer. They're asking him about the case, and he says this is what his position is. She's lying. She concocted this whole thing with her friends. She did this, she did that. So it's
I can't imagine doing anything else. I've had cases that have gotten press and the press contacts me and I say things that
Pam, you should be watching this too.
And what I believe.
This case is unbelievably fascinating. There is so much more in it than you're probably hearing about in the mainstream media. So watch with us. Love to have you.
I completely agree.
And thanks. Appreciate you being on.
David
Make sure you hit the like button.
Question, how many staff members and attorneys would be working on this case? A lot. How many can you afford is the question.
How many can they bill?
Yeah. Yeah. I mean, because it's like you've got the folks in the room, you've got the folks back at the firm that are maybe managing managing things from behind the scenes, watching it, seeing if there's anything that they need. You've got the folks that are, maybe not even necessarily the attorneys, but staff that are helping to arrange breakfast, lunch, and dinner for these guys, maybe arranging for them to get coffee, maybe arranging for hotels if they are needed. I mean, Camille's from Southern California. Ben Chu, I can't remember if he's from LA as well, but like
No, he's DC.
He's DC. Okay. But there's a number of these attorneys that have been flown in from elsewhere. And so there's a lot of coordination that has to happen. Then there's also the witnesses that have to be coordinated, whether they are coming in person or whether they are testifying via video link. You have to make sure the tech is working. You have to make sure that everybody's got notepads and
The
pens and
exhibits. Oh my
post-its and the
God.
exhibits,
Yeah.
exhibit binders. Like you've got to have all these transcripts ready. You've got to have somebody that has highlighted the transcripts with page and line number, so that in case there's an impeachment, if somebody says anything that is contrary to what they have said before, that you can go in and just very smoothly hand the attorney the page and line number and say, this is exactly what you need to use right now.
Everything aside, the people sitting in the second row look like they're doing nothing, but they are the absolute busiest people in this. They're the ones that have to have everything indexed in their head to go, here's the piece of paper you need to look at right now.
Yeah.
And all of us probably here have been in that chair, have been in that second row of you're just like constantly flipping, just, oh my God, writing constantly. And you're always behind. You didn't make the note on the right thing ever.
Yep. That's not my name. Thank you very much for your generous super chats. Kurt, I will insta subscribe if you do weekly recaps of law news in full sarcasm, cynicism, and annoyance. Kayfabe?
That's just
Uh,
my default personality, man.
Okay.
It's like,
Which-
You do that every
despite-
day, don't you?
I know. Which, despite being super entertaining, you seem to show more often in other people's channels than your own. Love you all. I think that's true. I think you do tend to be a bit more serious on your own channel than you are elsewhere. I think because you're just more relaxed elsewhere. Because you don't have to be the one like
I don't know.
This
I made one appearance on Kurt's channel, and it was, I think, after streaming all day here, and we were slap happy. And I'm like, this is fun. This is just a situation over here.
We need to have a bourbon stream, Kurt.
Andrea, where are your subscribers at?
Oh my gosh, you're gonna ask me a hard question. Let me go look right now.
No, that's not hard. We can find it. We can find it. But if you're close to 20K, we should get you there. 100%. There's no reason why we shouldn't. I'm at
19.
Oh my God.
Oh my God.
Guys,
Okay,
we can get her to 25. Why
reach
reach
the
20?
right now.
We can get her to 25, which, I mean, there are more people watching right now than there are subscribed to Andrea's channel. I don't understand that, because honestly, Andrea has had like the best commentary going into this. I mean, I learned about this case from Andrea and other people. She's been covering this case for years, and with such great insight as an attorney and as somebody who has just been covering the facts as well. She was for the longest time, she's been just showing up on other people's channels and talking to them about it. But now she finally someone has finally convinced her to start her own channel. And thank goodness, because it is a great service to the world. And I am so thankful that you have decided to start your own channel. And I'm really happy to have you as part of LawTube as well. And yeah, I mean, we should get you past.
I don't know if I'm subscribed. I'm going to subscribe to Andrea. What's the name of your channel?
Andrea Burkhart.
Andrea Burkhart.
Andrew Burkhart.
It's linked in the description.
I think I can figure that one out. All right.
If I may, you have the best background too.
Yes.
Best background here. Just saying. How it goes. We all got boring books or like plaques or whatever behind us.
I sometimes have a ninja cat, but that's about it. That's not always. But yes, yeah, absolutely. There's absolutely no reason why your channel shouldn't be at least twice the size of what
Guys,
it is.
it's over
3 times the size.
Thank you. It
Done.
took like 20
While they're talking
seconds for you to
about
say
liking and sharing and subscribing to their channels,
And yes,
well
let's
deserved.
Please do that for mine.
Because you're pushing 250,000 here, my friend.
Mm-hmm.
So
We are.
let's get that done. There are a lot of people, and thank you all for coming out. But there are a lot of
especially on YouTube. For those of you who are not
There's
on my
some-
YouTube
there's
channel,
some new
please go
subscriber,
subscribe. I'd appreciate it.
potential
Thank
here.
you.
No
Thank
doubt
you.
about it.
Thank you, thank you. But I think for me personally, I would love to see even more than that. I would love to see more people liking the video if that's possible. Just because the reason for that is when you do like it, that's the easiest form of engagement that YouTube recognizes. And so when you do like the video, YouTube recognizes that engagement and puts the video in front of more people out on YouTube, so that more people can get in contact with this kind of content, and we can steal them away from folks like Law and Crime and Court TV and all these other jokers that are giving a bland analysis that's not real, that's based on like what some other higher overlord is telling them to say. I mean, how many folks have heard something from Court TV or Law and Crime Network from some attorney saying this is a stupid case about, rich people problems and who cares about it? Like, a lot of people care about it, and for a good reason. So if you guys do, liking the video it helps to put this in front of more people, so we can steal them away from those jokers. Let's make this community bigger.
This
You
is
know what
such
I
a
mean?
golden era in legal journalism. I mean, I'm old enough that I can remember back to, big trials that were happening 10, 15, 20 years ago, and just trying to get anything approaching decent coverage by somebody who is knowledgeable about the law and can accurately communicate what is really going on and what the significance of it is. There's just been a huge vacuum that I think the success of LawTube speaks volumes about how badly that void has needed to be filled. And so I'm just so grateful to you, Alita, and to all of your panelists, everybody else involved in LawTube, to have created this opportunity to be able to give this kind of commentary.
So that's a very good point. When I was in law school, when I was 3L when OJ was happening, I just sort of skipped about 6 months of law school just to stay home and watch during the day. And Court TV was the only channel. That was it. There was nothing available. And even the mainstream media was taking the clips from Court TV.
Yeah, Andrew, it's a fantastic point, is that the media was all over the OJ trial, but there weren't a lot of journalist lawyers, I guess you would call it. So they were non-legal journalists commenting on stuff they didn't know much about.
Greta Van Susteren was pretty much it.
Yep. Yeah,
She was
absolutely. Yeah. Greta Van Susteren and like maybe Nina Totenberg. I don't know.
Yeah.
Yeah. Well, but it gave birth to all of the Nancy Graces and things like that of the world. So there was you take the good, you take the bad,
And with that, you get the facts of
So
life.
true.
Yeah, exactly. So it's it has been
Point
beautiful
for
to see
Kurt.
the growth, and hopefully it does continue, because I mean, how many people have you guys heard from that said, either from this case or a previous case that we've covered, some sort of a trial stream of, where somebody has said, I didn't know anything about this case. I just was following the reporting and the headlines and whatnot, and I thought it was this. Now, after watching the trial itself, I understand it is entirely different. And wow, what if I hadn't come across this? Like, how would my brain have been different moving on into this world? And so the idea that it's like, if we can be the ones, taking people out of Plato's cave, so that they're no longer just seeing the shadows on the wall, that is a huge win for anyone, right? So the more we can do that, the more trials we can do this with, the better, as far as I'm concerned.
I'm so grateful for this community, because I have people finally like me, and they're interested in things like me, and are interested in talking about esoteric things or deep things. Like, even in bar associations, I have tough times talking to lawyers about, deeper concepts and stuff. It's like they're not really interested. So I'm just grateful for a community where I have all these friends and I can talk to about stuff I care about.
Yeah,
Let's do a legal philosophy rule of law collab. Let's get into the Machiavelli and the Hobbes and John Locke. Let's do it.
Yes.
One of my first law review article videos is going to be on customary international law.
I'm sorry. That's what I
Bring
do.
us to
I'm
Nuremberg.
sorry.
You do customary international law?
I'm in Korea, and that's because Korea is a continental law system, and we deal a lot with the with the English law, the Anglo-American law. So yeah, you have to deal a lot with the customary law.
And correct me if I'm wrong, we both have Godzilla memorabilia behind us.
Oh yeah.
You're there. I've got my Criterion Godzilla Blu-ray box set right there. Yeah. Okay. Just saying.
That's the actual our Perry Mason actor back there. That was the poster, the 1935 poster, was it?
Okay.
And that's an actual road sign from Japan on the floor there. It's like a legitimate reflective road sign you could mount on a street sign somewhere. Yeah. But
I just made a new friend, guys.
Yeah, of course. And Bailey, did you guys cover the Derek Chauvin trial? Well, we did cover pieces of it. We did do some live streams of it. That was like right when I met. I'm getting a little.
All right, guys, I'm going to call it quits for the day on this particular trial. I appreciate those who stuck with me up to this point. I appreciate you so much. Thank you for joining me. If you want to continue to watch Legal Bites, go to her channel. You can sub to all these guys. They're fantastic. I've subbed to all, not most of them for sure, not all of them. And I will see y'all later. But I definitely plan on doing this again tomorrow. I'm super excited about what happens next. I'm really interested to see when Amber and her team run out of time, because it's under 4 hours now. It's got to be in the 3 hour some range, and they're basically just trying to buy their time until closing arguments on Friday. But with that, I hope you have a great day. I'm going to get some lunch. Y'all take care, and I will see you tomorrow. Take care. Like I said, if you want to continue to watch these guys on their channel, let's make it happen. See you tomorrow.